All right. All persons having business before the Honorable Chief Judge and Associate Judges now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God and the United States and this honorable court. This honorable court, now in session, please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We apologize for our brief delay this morning. We have two cases set for oral argument. The first is Earth Island Institute versus Coca-Cola Company. Counsel and parties, are you ready to proceed? I know we have Nikas for the District of Columbia arguing. Can you, I guess when you come to the podium, just explain how you plan to divide up the time? All right, counsel, if you're ready to proceed.
Thank you and good morning, Your Honors. My name is Renee Wickland and I'll be arguing on behalf of Earth Island Institute this morning, the plaintiff appellant. If the court does not wish more from me, my plan is to argue for about 9 minutes, save 1 minute for rebuttal, and then turn the podium over to our friends from the Attorney General's office.
All right, thank you.
So I'm sure the court is aware that this is a consumer protection misrepresentation case for injunctive relief under the CPPA. No damages are involved. At issue is Coca-Cola allegedly misleading DC consumers about its sustainability and recycling efforts. Earth Island Institute has alleged that Coca-Cola is sort of barraging DC consumers with what was termed as a mosaic of representations, creating the impression that its business and its sustainability are two sides of the same coin, and that Coca-Cola is taking a quote leadership position in tackling the problem of plastic waste. Examples of the statements that fall within that mosaic are these: that Coca-Cola is committed to creating a world without waste by quote taking responsibility for the packaging we introduce, that business and sustainability are not separate stories for the Coca-Cola company, but different facets of the same story.
So can you get us to the heart of what the misrepresentation is?
So what Earth Island alleges is the misrepresentation are all of these messages being aimed at consumers. The idea is that consumers, in fact, have become wary of plastic pollution and of buying single-use plastics.
Well, is it that Coca-Cola is not doing recycling, or they're not doing it the way Earth Island thinks they should do it, or they need to do more? Can you
No, Your Honor.
zero us in on?
Yes, it is certainly not a policy dispute about the way in which Coca-Cola is doing things. Instead, it's a dispute about whether Coca-Cola is living up to what it is telling consumers about what it is doing things. Things like what I just read, by actually taking responsibility for the single-use plastic packaging that it is introducing into the world. What Earth Island alleges is that Coca-Cola is making representations about its present conduct that it is not living up to.
Not
It is
living up to, meaning it not doing,
Not
or
doing.
not doing at all, or not doing as much?
Meaning that what they're doing does not match the way that consumers are being told that they are doing things. And also that Coca-Cola is making promises to consumers that it knows that it is not going to keep. So that Coca-Cola is assuaging consumers' fears about the use of single packaging plastic.
What is your best,
packaging.
I'm sorry, what is your best example of something in the present that a statement is promising or alleging in a concrete way?
I would say examples such as we are taking responsibility for the packaging we introduce, acting in ways to create a more sustainable future, using our leadership to achieve positive change, taking a leadership position on the interconnected global challenges of packaging waste and climate change. I think those would be some of the examples that imply present action.
So if they say they're acting in ways to create a more sustainable future, in what sense is that false?
What we believe, or what Earth Island has alleged, is that they are increasing single-use plastics use right now, and that is not something that is creating a quote more sustainable future.
Where is
But-
that allegation? I think sort of as a broad theme, what gives me difficulty in this case is I don't see a point in the complaint where you're nailing down what you think the misrepresentation is. I don't see where the complaint says they're not going to hit the 50%, 100% thresholds in 2025 and 2030, and they know that. I don't see a point where the complaint says Coca-Cola is in fact increasing single-use plastic. Where's that? I mean, when I read the complaint, it sort of reads to me like, yeah, they're doing some things, and maybe that does have some marginal but ultimately insignificant benefit for the earth because they're whistling by the graveyard that they are one of the world's biggest plastic polluters. Sort of, you can't say, you know, we're making a healthier cigarette. Even if you are making a healthier cigarette by some marginal amount, clearly you're making something horribly unhealthy. And that you're kind of saying here, Coca-Cola might be taking some steps to being more sustainable, but they are so insignificant in the grander scheme of the damage that they're doing that they're greenwashing their product. So do you think you're in fact saying that they're increasing the use of single-use plastics?
I think what we are going to improve, if we can, in court, is that they are not taking any steps that right now would be creating a more sustainable future. Because it, I think, is indisputed that they're continuing to put out single-use plastics while promising that they're taking steps to put this problem under control. And that is in fact not creating a more sustainable future as DC consumers would interpret that
I mean,
promise.
is sustainability, does it exist on a spectrum, or do you think it's sort of a yes or no question? Because can you make steps toward a more sustainable, can I put it this way? Can tobacco companies make a healthier cigarette that is, you know, only 98, if they make it 2% less deadly than the typical cigarette, have they made a healthier cigarette? I guess. But is that your kind of claim here?
I think that if a tobacco company told DC consumers, we have made a cigarette 2% less deadly, and therefore it's a less deadly cigarette, that would not be a misrepresentation. If Coca-Cola were to publish, you know, we are continuing to use single-use plastics and here's the realistic statement on it, and, you know, this is not sustainable, we wouldn't have a dispute. If say, Coca-Cola were to say, you know, our business model cannot possibly be sustained indefinitely. You know, we may have a policy
significant-
dispute, but not a consumer protection case.
I'm sorry, Council, to interject, but how significant to your claim are some of the allegations that Coca-Cola was actively working against legislation that would have facilitated their efforts to meet their goals towards sustainability? You cite to a couple of articles to specific pieces of legislation dealing with bottle use, bottle reuse, bottle recycling. How significant is that information to your claim?
To be clear, those aren't the misrepresentations at issue, but I do think that that is evidence that is pertinent to whether Coca-Cola is actually doing the things that it is telling consumers that it is doing. So we're not saying that Coca-Cola's advocacy here or there is a misrepresentation to DC consumers, but we do contend that is evidence that Coca-Cola is not living up to what it is promising the consumers.
And again, what is it promising consumers?
It's promising consumers that it is taking responsibility for the packaging that it is putting out into the world.
That seems like a very vague statement, to take responsibility for something. What if we take that statement in isolation, what is the question for the jury? You've heard all the evidence. Coca-Cola says they're taking responsibility. You are to determine whether or not you think, in fact, they are.
I think that there are two facets to that question. Your Honor began with, if we take that statement in isolation. Our position is that we shouldn't take the statements in isolation because the nature of advertising today, which we think is recognized in the CPPA, is not that you see statements in isolation, it's that you're hit with all of these statements from Coca-Cola. You know, we've lost the day when we tear out a magazine page and that's the advertisement. It's coming at you in your social media feed. It's coming at you on the website. It's coming at you on the Jumbotron. If you go to a Caps game, it's just coming at you in all forms.
So taking everything together in a sentence,
Mhm.
what's the thing that Coca-Cola is representing that you think is false and misleading?
We think the impression that Coca-Cola is creating is that single-use plastics are not going to be a problem or a problem that they can't get under control. So it is okay to keep purchasing them. And I think that that's the question that would be put to the jury. What impression have they created for reasonable consumers? And are they living up to that right now?
So that it's that single-use plastics aren't a problem because they can be controlled via recycling. You think that's roughly the misrepresentation they're creating? That all these advertisements and statements could be a reasonable jury could interpret them to mean that plastics aren't going to be a problem, and that all the evidence, I know we're at the motion to dismiss stage, that you're going to present evidence that says, in fact,
I think it
single-use
would
plastics
be
will be a massive problem.
that it's not a question of will be a problem. It's a question of single-use plastics are a problem that Coca-Cola is currently actively getting under control. I think that's more of it. I think that they would agree that, I hope that everyone would agree that there's a problem. That's why we think these representations are being made to get consumers to continue buying the product, even though there's a problem.
And if they're taking some steps to getting it under control, would that defeat your claim?
No, I think it would be a question of what the reasonable consumer would think from these promises that they're making and whether in fact they've done that.
Well, Coca-Cola says in its briefs that they've taken the steps that they can take toward minimizing the impact of plastic containers on the environment, but they're hampered by the infrastructure around recycling that is beyond their control. And I mean, that resonates with me. I mean, to some extent, we've done our part essentially, and we'll continue to do our part to minimize these things, but we can't control where the recyclable bottles are taken after people put them in their recycling bins, or isn't that a limiting factor on how reasonable consumers would and do interpret Coca-Cola's representations?
I think that's a great point, and that comes down to policy. And I do wish that if that's the point, then Coca-Cola wouldn't be saying, we're taking a leadership position on sustainability, go ahead and buy these, but would be saying, we have a problem here. We can't take responsibility for our packaging because once we sell it, it's out of our hands, and that's a problem. But that's not what's being said to consumers. What's being said to consumers are, for example, those examples that I just read, and all of these sort of positive feel-good statements about what's going on, and not a realistic position like Your Honor has just articulated.
One thing Coca-Cola does in its brief at pages 3 and 4 is it says, look, we've hedged these statements throughout the advertisements and the websites that you're pointing to. We have painted a complete picture. And they say, and you can take these statements into account, even though they're not in the complaint. And I don't understand you to be disputing that. Is that right?
That's correct. We wouldn't dispute that.
So if Coca-Cola put a disclaimer on its website, which is sort of where a lot of these statements are coming from as part of its sustainability plan on its website, that said, while we're taking these steps, Coca-Cola is one of the world's principal polluters, and single-use plastic is one of the greatest culprits of contributing to global warming, and nothing short of stopping its use will really stave the problem. Would that satisfy? I mean, part of this goes to what do you want when you say you're asking for injunctive relief, which is quite unclear to me what that injunction would look like. Is something like that? Is that right? Is that addendum to these statements sufficient?
So I think there's a few questions in there. The first question is, do we dispute that we can look at the whole website? We don't. In fact, to the contrary, I would ask Your Honors to please go and look at the website, because it's hard to convey in the complaint just how prominent and promising these representations are. But if you look at the website, you will see more of that. And I think we need to remember that this went out on a 12B6. And, Coca-Cola, those pages in the brief, pages 3 to 5, it's all about, oh no, there's a fact issue here because elsewhere we've qualified that. And I think it will be something that in discovery we're going to have to address. If you look at the main page, but no, you click over here and then click over there, you see a disclaimer. Is that sufficient? That's certainly going to be a fact issue that we'll need to address, but it is a fact issue. And I believe that the Superior Court's finding that there was no fact issue here was in error at that point.
So the injunction that you seek would be what? To cease all advertising, to cease all mention of recycling, to
No.
cease, so how do you frame?
I think we would be reliant on the good judgment of the Superior Court to help us craft what that would be, but it may be something resembling, what's in the green guides. Don't be making unqualified statements about your sustainability when you're saying if there's only, 4 clicks away, there's a disclaimer to those statements or something like that.
Can I ask one more question? And I know we'll hear from Amicus in a second. Do you have a way of distinguishing Bimbo Bakeries out of the 10th Circuit, or is your view that that is just wrong?
The particular holding of Bimbo Bakeries.
Yeah, I mean, that was the one with the bread that said fresh, local, quality, and the 10th Circuit said, the claim was local would convey to an ordinary consumer that it was made within the state. This, in fact, was not made within the state. The 10th Circuit said, no, local is just too nebulous a word to carry sort of that factual meaning, even if that's how consumers might interpret it. And sustainability is sort of the same. Sustainability is a pretty nebulous term that I don't think throughout the briefing or today's discussion, we've done much to nail down in terms of a concrete meaning, and that local is the same way, is roughly the 10th Circuit's reasoning.
Yes, I would compare that to this court's decision in Pearson v. Chung, satisfaction guaranteed. Just is that being out there? If that's on the wall, is that enough? Is local enough? But I think that we have more than that going on here. I think there's a few dozen sort of representations around these points that are set forth. It's more than just sustainability written somewhere. There are more specific representations, and we think that Coca-Cola is intentionally making them work together to create an impression that means, something more than simply the word local or the words satisfaction guaranteed. And I do think that, we know that the CPPA is broader than statutes elsewhere. We also know that there must be a reason for the reasonable consumer standard. I mean, if it was all sort of what Coca-Cola alleges, the statement must be an objectively factual statement, there would be no reason for the reasonable consumer statement. It would be either, we go to the dictionary, we look up this word, they did it or they didn't do it. We don't have that. We have a standard about how is this interpreted and do they meet how it's been interpreted by DC consumers.
All right, thank you. We will reserve your time for rebuttal and we'll hear from Amicus.
Thank you, Your Honor.
Thank you, Your Honors. And may it please the court, Caroline Van Zyl on behalf of the District of Columbia. I'd like to pick up where some of the court's questioning left off regarding what you do with claims that a business is quote unquote sustainable. And I'll focus on 3 specific claims that are on Coca-Cola's website in walking through how we think that analysis should work. So as my colleague said, there are several comments that are just on the website available to consumers, including comments about taking responsibility for the packaging we introduced, acting in ways to create a more sustainable and better shared future, and notably a large logo just saying sustainable business transposed in front of a field of grass. Those are all on Coca-Cola's website. And we think that the misleading impression that creates could create to a reasonable consumer plausibly is one of 2 things. 1, that the business is unqualifiedly sustainable, and 2, that they take responsibility for their packaging in the sense that for every unit of pollution that they put out into the world, they are doing something substantial to either largely or entirely mitigate that. And what the complaint says is that the facts on the ground simply belie that impression when Coca-Cola is the world's largest plastic producer, when it puts out 2.9 million tons of plastic waste per year, 200,000 bottles per minute, and 33 football pitches per day worth of single-use plastic. And what the green guides say about this, I think is very important. As you know, our statute says that FTC guidance must be given due consideration and weight. And the relevant FTC guidance here is from section 16 CFR 260.4, which governs general environmental benefit claims like sustainable business. And it says, and if the court will indulge me, I'll quote for a while here because I do think it's very helpful. It is deceptive to misrepresent directly or by implication that a product, package, or service offers a general environmental benefit. Unqualified general environmental benefit claims are difficult to interpret and likely to convey a wide range of meanings. In many cases, such claims likely convey that the product, package, or service has specific and far-reaching environmental benefits and may convey that the item or service has no negative environmental impact. Because it is highly unlikely that marketers can substantiate all reasonable interpretations of these claims, marketers should not make unqualified general environmental benefit claims. So in the green guides, in general, the green guides have existed since 1992. This is not a new issue. Companies have been on notice for quite some time that they do need to tread carefully when they're
But
making
is
environmental.
our Coca-Cola's claims around sustainability as general as you are representing? I mean, they cabin some of their statements to some extent. So they can't say anything about sustainability unless they say everything about sustainability, or where is the guiding principle that should help us here? Because they don't just, the website doesn't just say, the materials don't simply say we're sustainable. We promote they say we work towards sustainability, and they have some other details about the work that they are doing. Now, that doesn't mean they're doing everything, but where on the spectrum are we with the use of the word sustainability? And, I'll just let the question stop there.
Well, in general, I think they are free to say anything that is true and not misleading. And so I think we have perhaps a slight difference of opinion with our friends at Earth Island about some of the claims about making a 100% paper bottle, right? That is true. If that is all that you say, I don't think that it is misleading. It's concrete. We think that they can say things like that, again, if they're true and not in context, cast in a misleading light. They just have to be careful about getting out over their skis and saying things like sustainable business, or we are acting in ways that are sustainable, which hit at the very heart.
What if they said, well, we're acting in ways that are sustainable, but we still are the largest bottler of soft drinks, and so we do use cans. We don't use bottles all the time. I mean, what qualifying? What's missing from what they represented?
I think that there are a number of ways that they could qualify the statements to make them non-misleading. The court was talking about injunctions earlier. I mean, one option is to take down the statements. Another option would be to say, look, this is the volume of waste that we are putting out. This is the percentage of it that actually gets recycled. Here are the things, the concrete things we are doing today to mitigate that, but it's not enough. Now, they do make some disclaimers, but I would just suggest that those disclaimers, when viewed in the context of the website, are simply not enough, or they're themselves too airy to make this not a jury question or even resolvable on a motion to dismiss. Their disclaimers include things like, the world has a packaging problem, not exactly Coca-Cola taking responsibility for its packaging problem. Waste is a huge and growing issue for our world. We have more work to do. In the context of the volume of misleading statements that are on the website, and again, I think there are a lot of statements at issue here. I think if the court is looking for the most efficient and simplest way to resolve this case, I would focus on the misrepresentations on the website and any caveats that are on the website. And I think the court will find that the misrepresentations, which are really stacked one on the other. When you visit the website, the first thing you see is this scrolling carousel of images, one of which is a big green world without waste. We're working towards a circular economy, followed by sustainability goals and progress and pictures of windmills and trees and leaves. I mean, the impression that creates, I think it would take quite a lot to mitigate. And I think, again, the green guides can be very helpful here. There's a specific example in 260.4D of a laser printer that's advertised nestled in a bird's nest surrounded by trees, and it just says, make a change. And the green guides say that that is misleading, that is deceptive, because you're conveying that a product has a general environmental benefit that it does not, in fact, have. And contrary to Coke's representations, that's not measurable in a traditional sense, right? But it can still be deceptive or misleading. So we would caution the court to be very careful in potentially adopting these tests that Coca-Cola has proposed that are largely drawn from the Lanham Act, a federal statute that's much more rigorous, involving the need for some sort of measurable representation.
Coca-Cola asserts that what's missing here is a nexus to their advertisement and some good service or harm. Coke cites many cases in their briefs, but not many cases from this jurisdiction. What case law would be controlling on that issue in terms of how we would interpret our CPPA?
So we do think that brand and issue advertising can be deceptive. Unfortunately, this court doesn't have a case. I think the closest case that comes to mind, well, there are two. One is actually a First Amendment case, but talks about how brand or issue advertising can actually speak to and advertise products. That's a Seventh Circuit case called Jordan versus Juul. Massachusetts versus ExxonMobil also goes through this to some extent. And for purposes of the CPPA, we think the requisite nexus to the product or service is specified in the text of the relevant provision. So in 3904, there are several provisions that do require direct misstatements about the product or service. There are others, though, that don't. And some of those are E, F, and F1, which generally talk about misstatements of material fact or misleading representations. And in those circumstances, we think the right way to go about it is just to ask if the misrepresentation or omission would be material. That is, would a reasonable consumer attach importance to the existence or non-existence in determining his or her choice of action in the transaction? So it goes back to whether it would be important when you're deciding whether to buy the product or not, even if the statement itself doesn't have to be about the product.
Everything that you're, I'm sorry. Go ahead. Everything, go ahead. You were gonna.
I had a non sequitur question about how I don't personally look at the website if I'm deciding what soft drink to buy. But some people do, and some people think about the environmental impact of a product that they're going to use. So that was just a non sequitur. I'm sorry.
Everything that you're talking about, or a lot of it, just seems like the kind of thing we know juries are supposed to decide. Like, is it misleading? When you were talking about the disclaimers, I missed what you said, but I thought you said something about it wouldn't be a jury question, but wouldn't disclaimers be something the jury would also wrestle with?
Oh, absolutely. And if I said that, I certainly misspoke. I think it would be a question for a jury as to whether that total mix of information would in fact be misleading. And just to give a little more specificity to the question about how tethered does a statement have to be to a product or service, because I do think that is one of the most difficult questions in this case. Let me give you some examples of why I think it is important that this court not close the door to brand or issue advertising being misleading. I think that kind of advertising can be misleading for one of two reasons. The first I will call sort of the transitive property of advertising. In other words, sometimes when you're talking about the brand, you're implicitly making representations or misrepresentations about the product. So an example I would give is if McDonald's launched an advertising campaign tomorrow that just said, "We're vegan. Double arches, happy people, we're vegan," but did not change its practices otherwise at all. Still sold Big Macs, still sold Chicken McNuggets. Now, a reasonable consumer looking at that, even though it doesn't feature the product or say anything specific about the product, would of course interpret that to be about the product that McDonald's sells, which is food. They would interpret that as saying the food is vegan. I think that that would be one easy way to resolve the nexus issue in this case, because I think similarly, the statements here about Coca-Cola taking responsibility for its packaging or being sustainable, what else could they be talking about but the beverages and the bottles? The other way in which we do think that brand or issue advertising can be misleading, which is a little bit broader, is what I will call the values are valuable theory, the theory that some consumers are willing to pay more for brands that represent that they are doing good in the world in certain ways. So take Tom's shoes, for example. For a long time, their advertising campaign was, if you buy some shoes from us, we will give a shoe to someone in need. And people viewed that as being material. People could plausibly buy Tom's shoes because they thought, well, you know, regardless of whether I like the shoe itself or not, Tom's is going to do something good in the world because I made that purchase. And if that were false, that could, under the CPPA, be materially misleading to a consumer. And we think some of these general statements about sustainability and Coke could be taken in the same way.
Can I ask a question? A similar litigation took place in California under the California statute, if I'm not mistaken, involving Coke and Earth Island. And with a different outcome, I believe. Was that based on the difference in the statute? And if you're not familiar with the case, then don't.
I have
speculate,
not looked
but-
at that case very specifically. I do believe the actual underlying factual allegations and claims were different, but I will defer to my friends at Earth Island for exactly the best way to distinguish that. And I suppose the one last thing that I would say in closing is, to the extent that this court is worried about juries wrestling with terms like sustainable, there are many other cases where similar things have either gone to juries or to bench trials. For example, in the Hormel case in footnote 9, the court noted that the term natural could have many meanings, and what it would mean to a reasonable consumer was actually a question for the jury to resolve. Similarly, in Pearson, that was actually a bench trial case where satisfaction guaranteed became a question for the trier of fact. And actually, the trier of fact was able to put some teeth to what that term would mean. It just wasn't exactly what Mr. Pearson hoped that it had meant to a reasonable consumer.
Can I just ask if what limiting principle there is to sort of the reasonable consumer? And if I could, I'll just piggyback on a tweaked version of your McDonald's example. What if McDonald's, and I assume this campaign actually exists, says, we're working to make a healthier product. In fact, McDonald's is horribly unhealthy, but they are in fact taking, you know, they now serve some salads, or I assume some lower calorie wraps or something like that. But by and large, does that get to a jury if somebody says, by saying you're working to make a healthier product, you are sort of snowstorming the fact that you're a wildly healthy option, even if it's true? Does that get to a jury?
So I think with no additional context, that's very unlikely to get to a jury in that. So if you're analyzing a forward-looking opinion statement like that, the Supreme Court in Virginia bank shares, I think, helpfully identified two ways in which those can be actually misleading. And then there's the separate question of materiality, right? Opinion statements like that or aspirational statements can be misleading. One, if they're not truthfully held, and in your hypo, it is truthfully held. And two, if they imply facts about the world that simply aren't true. And I don't know, just the bare statement, we're working towards healthier food in general implies, I mean, you would have to suppose that implies.
You could just map it onto these facts that makes it easier. You know, by 2025, we'll have cut the calories in our average meal in half, and by 2030, let's say they're actually working toward those goals. Mm-hmm. But still, no matter what they do, it's going to be super processed food that's wildly unhealthy. So why wouldn't that get to a jury under your view? I mean, I'm kind of just like reaching for a limiting principle mm-hmm. here, which is, I don't know why better ingredients, better pizza, Papa John's doesn't get to a jury under your view if you could show hey, court, this, they show pictures of an Italian chef sprinkling cheese on pizza, and it makes juries think this is going to be good. And then you try it out at trial, you feed some to the juries, and they're like, actually, this isn't as good as we thought. Why? It just seems like every piece of advertising that I come across, and I understand this as a consumer, is putting a rosy picture on a product. And if that rosy picture doesn't totally align with reality, well, that's just kind of what I come to expect with advertising. And why, do I have any assurance that that's not the universe of litigation that ruling in favor of Earth Island Institute here would open up?
I think you do, Your Honor, in that we agree that puffery is not actionable under the CPPA. Better pizza, better ingredients. That's classic puffery. Puffery is generally going to be something that no reasonable consumer would rely on. In rare occasions, that can be determined, even at the motion to dismiss stage, as a matter of law. And generally, it's going to be about something that's a matter of taste or some vast overstatement about the quality of the product that just simply is inherently incredible, or as this court put it in Center for Inquiry, facially implausible, right? Happiest place on earth, Disney World, right? No reasonable consumer is going to rely on that. But I think that is a world apart from taking responsibility for the packaging we introduce, or even—
Why is it implausible that Coca-Cola can meet the goals it discusses by 2025 and 2030?
Well, to be clear, if the goals alone were the sole allegations here, I think this would be a much, much, much more difficult case. I would apply that same Virginia Bank Shares type test of, is there a plausible allegation in the complaint? So there are two issues. There's materiality and falsity. Let's talk about false or misleading first. To prove that they were false or misleading or plausibly alleged even, you would have to have facts showing either that they truly didn't believe in the goal, they had no intention of meeting the goal when they said it. Now, we do have allegations in this complaint that they've blown through very similar goals in the past, so maybe that gets you across the line. Or you would have to have allegations that they imply some facts that are true about the world, that our bottles are already more recyclable than they actually are, for example.
If those goals for 2025, 2030 are in what they say on the website about their recycling, along with some other statements that may be more aspirational, does that mean you get an injunction on their entire advertising plan on sustainability? Seems like we have a mixed bag of statements at best here.
That's fair, Your Honor. And I do believe that the Superior Court would need to carefully craft the injunction. At this stage, though, as a procedural matter, we're here on a 12B6 on a single count complaint. So if there are, say, 3 allocations on the website that you thought plausibly would be materially misleading to a reasonable consumer, that means the complaint goes forward. Now, if down the line, Coke wants to either move to strike some of the other allegations to narrow the issues or ask for a very specifically crafted injunction, of course, it's their prerogative to do that. But right now, all the court is tasked with deciding is whether there's enough in this complaint to sustain a single CPPA count.
All right, thank you. Unless my colleagues have any other questions, we appreciate the amicus role and argument here. We'll hear from counsel for Coca-Cola.
Thank you, Your Honor.
Thank you, Your Honor. May it please the court, Steve Zalison, appearing pro hoc vice for the Coca-Cola Company. I appreciate the opportunity to present argument today. Let me start, Your Honor, by answering the Chief Judge's question about the Earth Island, California litigation, just to get that out of the way. There isn't a different outcome. In fact, it's the same outcome. So the complaint in that case raised 2 theories. It's a multi-defendant case. Coca-Cola is the first named defendant, but Pepsi and Procter & Gamble and a lot of other consumer products companies are also named. The first count is for public nuisance, that the plastic waste litters beaches and waterways and what have you in California, and that the defendants should clean that up. The second count was for violation of California's Consumer Legal Remedies Act, which is their version of the CPPA. It's their consumer protection statute.
Does it differ? Does their statute differ in any material way from?
It is
the
not,
district's?
it is not, Your Honor. And I know that there are statements in this courts and in Superior Court jurisprudence that the CPPA has a broad remedial purpose, but all consumer protection statutes do. And this court often looks to decisions by other courts on their local consumer protection statutes. In any event, the trial level court in that case dismissed both counts as insufficient. The CLRA or CPPA analog claim had to do with the representation that these products are recyclable. And like Earth Island in this case, that complaint alleged that recyclable implies that the product in fact will be recycled, or there's a high probability that it will. And the court, like every other court that has addressed this issue, disagreed with that. Recyclable means able to be recycled. And so long as there are facilities available to at least 60% of the community in which that claim is being made to recycle, in this case, a PET bottle, which is the most recyclable form of plastic, the Federal Trade Commission Green Guides say that you can make that claim without qualification. There's no need to say rates of recycling may be lower than in your area than in some others, check rates, et cetera. So those claims were dismissed without prejudice. An amended complaint has been filed. There's a pending motion to dismiss. It's actually called a demur in California State Court as to the amended complaint. But that's the cases are proceeding roughly on analogous tracks. Now, I want to pick up where Amicus left off, because we finally got to the word puffery, which was the first time in the last minute, perhaps, I heard that word mentioned. And this case is about puffery, pure and simple. The statements at issue, our planet matters, we act to create a more sustainable future, we want to make a difference in people's lives and our communities and our planet by doing business the right way.
Is it, what do you think it means if on the website where it just says sustainable, how would you interpret that?
Yeah, so sustainable, Your Honor, is actually a word that has attracted some judicial attention in terms of what does that mean? And courts have wrestled with this. Judge Rigsby, Robert Rigsby, has held that the word sustainable is puffing, as an expression of opinion when used by Bigelow Tea to describe its products and its operations. That's the Organic Consumers Association versus Bigelow case from 2018. So there is no single definition of sustainable. It's one of those kind of squishy words that is not capable of measurement or being proven true or false, and it falls under the category of classic puffery.
Is it possible that the sort of nebulousness of the word sustainable, it's nebulous in a consumer's mind too, but a consumer still knows they want that, whatever it means. And so as between two similar products, if one says sustainable, I'm buying that one.
Well, okay. I mean, I think so. Earth Islands Council described these statements, including the word sustainable, as quote, positive feel-good statements. And I would agree with that. It does make you feel better to hear that there's a focus on sustainability from the seller or the manufacturer.
I don't know. I don't know about there being a focus, but it is sustainable.
Sure. Well, so the context in which these statements are being made, Your Honor, is obviously Coca-Cola is the largest beverage company in the world, and it does produce a lot of plastic packaging, which does create waste and does create a problem. One of the statements that Amicus read but didn't finish, she read the first sentence, the world has a packaging problem. The very next sentence in that document is, as one of the world's biggest beverage companies, we have a responsibility to help solve it. So we are taking responsibility, but the description of what Coca-Cola is doing to make its operations more sustainable, we don't stop with that word. We explain we are making our packaging recyclable. We're in excess of 90% right now. We have a goal to get to 100% by 2025.
But aren't these fact questions that
I
Or a
don't.
jury can decide whether it's misleading or not after discovery
So-
or after.
So, Your Honor, the question of whether a statement is puffery or not, and also whether it's about goods or services or not, those are questions of law that courts decide at the motion to dismiss stage as a matter of course all the time. And there's been two cases mentioned here. One is the Better Ingredients, Better Pizza, Papa John's case. That actually went to a jury, went all the way through discovery, went to a jury. The jury found for the plaintiff, found that slogan was misleading, only for the Fifth Circuit to say, you got to be kidding me, that's puffery.
No, not exactly. They upheld part of the verdict with regard to it comparing its own ingredients to Pizza Hut's.
In the context of certain meat toppings and so, yes, yeah, that's right, Your Honor. But on the pizza box itself, just or on a napkin, they said that's puffery.
I mean, part of their argument, though, is sustainable is not like better. This is not Coke, best product in the world. That's puffery. Nobody would take your word for that. You're marketing something. Their argument is sustainable means something that's not going to be cataclysmic for the earth. It at least means that, and you don't cross that threshold.
Right.
So I take it. Now, we might use the word puffery. I might use it somewhat differently from you. I take it as a separate kind of doctrine than opinion versus fact. But I take puffery to mean so over the top that nobody would actually believe that as a true statement. And I don't think you're standing here today saying when Coca-Cola says it's a sustainable business, nobody would buy it. Nobody would buy that. That's not your position.
Your Honor, this court said in Pearson that puffery actually has a variety of definitions. One is the exaggerated over the top. Another is vague. Another is on which no reasonable person would rely. Or, and this is the important one, whose truth or falsity cannot be precisely determined.
Well, then
So
what
vague or whose-
point is there? We have case law saying that statements don't need to be false to be actionable under the CPPA.
True. Yeah.
How is that true? I mean, you just said that it's only actionable if it can be shown to be true or false. What room is there left for misleading?
Well, false or misleading is misleading as to a material fact. So if a statement, because it omits a material fact, or it says, I don't know, you'll never find a faster hairspray or some such thing, but it sounds like they're making a claim that this is the fastest one you can buy. But if you read it, parse it carefully, it implies something that is affirmatively false. That's a misleading statement. The word sustainable, when Coca-Cola is talking about its overall business operations, and they never said this plastic bottle is sustainable or the product itself is sustainable. It described its business philosophy, its goals, its aspirations, or as the Superior Court in this said, its ethos, as being focused on improving its sustainability track record.
So why isn't what's misleading here that Coca-Cola does not have a square acknowledgement that it's one of the biggest polluters in the world on its website alongside its claim of sustainability? And maybe it might make things easier to use the cigarette example. What's your view about a Marlboro campaign that says working to make a healthier future? We are taking steps to reduce the tar in our cigarettes. We are making faster burning cigarettes that emit less chemicals. And if you actually looked at the data, there is true statements. But as I put it before, whistling by the graveyard, that they're still one of the most unhealthy things you could possibly have.
I think that the problem with the hypothetical, Your Honor, is implicit in your hypothetical is that these things that they're doing, while literally true, have no actual material effect on the healthiness or unhealthfulness. It's always going to be an unhealthy product. What Coca-Cola is doing, and there's no allegation that any of these goals or plans that have been announced and are being pursued are insincere or implausible, or they're not going to be met. There's no allegation like that, other than that there's some goals we didn't meet in the past. And that's, this court has said many times.
That picks up on a question that I asked the amicus counsel, that there are in fact goals of meeting where Coca-Cola says they will meet in 2025 and I think 2030 and
2030, yeah.
beyond, of specific things that will be done towards sustainability and meeting that goal. So I'm curious as to why you so readily concede to the puffery allegation if some of the things on the website don't appear to be inherently misleading to me.
Well, Your Honor, to be clear, what I'm saying, I'm using puffery in slightly and perhaps a broader sense than you might be using it, because it encompasses aspirational statements and goals in the future that can't be measured today unless they're can be alleged plausibly to be just phony or false at the time they're stated,
So which
as
of
well
those
as vague.
statements
Hmm?
of Coca-Cola's fall into that definition?
Well, the goal statements, Your Honor, are in fact not actionable because they're phrased as goals. Unless, again, if there was a plausible allegation in the complaint that Coca-Cola in fact has no plan, no goal, and is simply lying to consumers when it says we're going to make 100% of our packaging recyclable by 2025. If they had a document that they cited in the complaint that said that was insincere, that might state a claim. But they don't have that. All they have is, well, you say this goal and it makes it sound like you really care about this, but meanwhile you're doing all these other things that are worse.
Lobbying against legislation that would facilitate reaching those goals.
In the
according to
past,
them.
if you read the complaint carefully, it says that today Coca-Cola supports bottle bills, and the facts are that there's somebody in Georgia who said, well, they're not gonna go and support bottle bills now because Coca-Cola is doing a lot for recycling infrastructure, and so they're not going to advocate for those bills. That's a far cry from saying we no longer support those bills. But again, Your Honor, what we have here is either aspirational statements about future goals that are genuine. There's no allegation to the contrary in the case. They're plausible and they're being worked towards. And the real issue here is that Earth Island, as a policy matter, thinks that recycling is a bad public policy. They think recycling is not the answer to plastic packaging waste. And
Can I bring you back to the cigarette example? Because you
Yes.
told me what the problem with the hypothetical was,
Yeah.
but I didn't hear an answer to it.
sure. So-
Does that get to a jury? Are the cigarette companies being false, misleading if in fact they do something that negligibly improves their health outcomes, but keeps them as one of the most unhealthy things a person could do?
I think the issue that could get to the jury there, Your Honor, is if people took away that the cigarettes themselves aren't today healthy or significantly healthier than they used to be, or are going to be a healthy product in 2025 or 2028, whatever the goal is. We don't have anything like that here.
I think what they're saying is you've given the impression that single-use plastics are compatible with long-term sustainability, and that's false. I don't know if that's false. That's the rough allegation though, right?
That is a policy statement if ever there was.
I don't know what that means. What do you
Well-
mean it's a policy statement?
Well, for example-
Can a reasonable consumer have an idea of what that sustainability means? Won't be cataclysmic to the Earth's environment for the next,
Sure.
50 years?
Let me give you an example, Your Honor. So in the District of Columbia, the district has this very ambitious zero waste program in which they talk about reducing the amount of waste that they set goals in 2028 and 2032, very similar to Coca-Cola's goals. And they talk about improving recycling infrastructure and say that, we're going to really encourage consumers to recycle. We're going to improve recycling rates. We're going to improve infrastructure, and the outlook is bright for recycling. You can take Earth Island's complaint, cross out Coca-Cola, and write the District of Columbia and wind up with the exact same allegations, because they will say, if asked, that recycling is never going to get rid of the problem of plastic waste. And Coca-Cola never said it's a panacea, but it is the primary policy and the primary approach that municipalities and industry are taking today to address the problem of plastic waste. And it is a problem that everybody acknowledges. But if you can get more recycled, more material recycled, use more recycled material, which is
What does that mean? That Coca-Cola's claim that it will increase the recyclable material,
Mhm.
recyclable bowl.
Yeah. So
material.
it-
Does that mean more plastic bottles or more, how do you make a plastic bottle more recyclable?
Well, so there are different, first of all, there are different resins, so there are different types of plastics. Right now, the resins in use are predominantly, as I said before, more than 90% recyclable. We're working toward getting to 100%. We're also investing in infrastructure to make sure that for every single bottle or can we sell, we collect and recycle at least one. And importantly, the market for recycled plastic historically, or at least in recent years, has not been as strong as the market for virgin plastic because it's perceived as being of inferior quality and it's actually more expensive to work with recycled plastic. Coca-Cola has made it a goal by 2030, nevertheless, to incorporate 50% recycled material into its finished products, which is going to increase the demand for recycled material and improve this rate of what Earth Island refers to as circular use of materials. But that's what Coca-Cola is talking about doing. Earth Island thinks that that is insufficient or misguided, and that we should get rid of plastic packaging altogether and replace it with something else. I don't know what the something else would be, although we're investing in, for example, the paper bottle that was brought up. But that's what municipalities and industry and governments across the country, including in the district, currently are doing, and we're participating in that. And there's no misrepresentation here about anything that we're doing, and there's no suggestion that.
Let me poke at that. And maybe I'm going to try a different example to see if it might not help. New Year's is around the corner.
Mhm.
And let's say I tell my wife, my resolution for the New Year's, I'm going to be healthier.
Okay.
Let's say I smoke, I'm a heavy smoker, I'm a heavy drinker, I eat steaks at least once a day. And February comes around and she notices that I'm still a heavy smoker. I'm still a heavy drinker. I'm still eating a steak once a day. And I say, yeah, but haven't you noticed that on my morning walks, I go an extra 100 feet? I'm being healthier. I certainly am. Do you think she would have a valid complaint that I've misled her?
Not under the CPPA.
That's kind of a remarkable answer,
yeah.
Because why isn't it a misrepresentation to tout something so negligible? I don't know that it is negligible. This is on a motion to dismiss, but
Yeah.
I believe Earth Island Institute's allegations are what Coca-Cola is doing is not a meaningful step towards sustainability. It is something that's so negligible, but it portrays to consumers that it's meaningful. In much the same way that me walking an extra 100 feet a day would seem negligible toward my health, given all the other stuff that I'm doing in the hypothetical. And I would think she would say, yes, of course I've been misled.
Well,
You told me you were going to do something, and instead what you did was, yes, something, but negligible. And I think what they're saying is what you're doing is negligible, and that might be wrong, that might be right, but that's not something we can really assess at the motion to dismiss stage.
Here's the problem, Your Honor. Your promise to your spouse that you're going to be healthier is a very vague and ambiguous statement that can't be readily defined or measured. If you said, I am going to cut 1,000 calories a day out of my diet, I'm going to stop eating red meat and animal products, and I'm going to jog a mile a day or 8 miles a week, whatever, that would be a measurable statement that could easily be shown to have been false or deceptive at the time it was made. Or if you could just say, I'll give you a less extreme example. If you said, I'm going to exercise a lot more vigorously than I have been. Okay, that's somewhat more specific. And then you only add a minute a day to your workout routine. That sounds like a pretty a violation of a promise that you made. That was a promise that was reasonably measurable. But I'm going to be healthier, or I'm going to be more sustainable, or I'm going to be more environmentally friendly. And again, these words, environmentally friendly and sustainable, are exactly the words that were at issue in that Organic Consumers versus Bigelow case I mentioned earlier, which were held in 2018 to be non-actionable opinion or puffery. So it has to do with the ambiguity, vagueness, and unmeasurability of the statement that is being made. And
Can I
these
just
But do
say-
you-
Sorry, please.
Do you mean the statement that we're going to do something? Because I keep coming back to this sustainable in itself, that message, we are sustainable, it is sustainable or something, which seems, I don't know if you mean to say that the goals for 2025 and 2030, encompass what to me seems like a completely separate message of sustainable, but it is that it's either puffery or it's a vague statement of future intent that can't be measured. I mean,
those are some of the definitions of puffery around it, but your sustainable business, which is the actual phrase at issue, not sustainable Coca-Cola beverages or sustainable packages, but sustainable business, which then goes on to talk about right underneath that graphic about what they're doing all over the world to improve the environmental and sustainability situation in communities throughout the globe, is a vastly different statement from this plastic container causes no harm to the environment. I mean, there's never been a representation like that. And there never will be, because that's not what Coca-Cola believes, and that's not what it has said. But it has said is that it recognizes that as the largest beverage producer in the world, which uses a great deal of plastic packaging, it has to find ways to reduce its environmental impact, and it's working towards becoming a more sustainable company. One of the allegations.
why does it have to work to become a more sustainable company if it's already sustainable?
Well, because first of all, we are sustainable. And in fact, the allegation in the complaint that consumers would take away from this melange of statements, which is a separate issue, whether you can aggregate them, but they would take away that Coca-Cola is today a quote, unqualifiedly sustainable company, I think is candidly ridiculous. When you actually read the statements in context, it's the world's largest beverage company admitting that it has to do more to improve the impact of plastic packaging, of which it is the greatest user. And it is doing those things. And that is what it has labeled sustainable business. But that broad label is not a representation that today we are an unqualifiedly sustainable company, whatever that means. I don't know what that means. I don't think they can tell you what that means. And just as in your example, Judge Deal, I don't know what it means to say I'm going to be healthier, but I do know what it means to say I'm going to exercise a lot more, I'm going to eat fewer calories, or something that's more specific. And the statements at issue here are, as counsel said, general positive feel-good statements. They're corporate ethos. They're not about goods or services. And by the way, there is a case, and you sat on the panel, Judge Beckwith and Floyd, where this court held that the bank in that case, which put out a 10-digit telephone number, which connected to an overseas call center, which didn't abide by US privacy laws, that was not goods or services within the meaning of the statute because it didn't pertain to its services as a bank. So it's not everything a company says or does that may somehow impact what a consumer wishes to purchase or not. You can have a company that says we believe in a diverse workforce. We support the rights, or we want to help parents have a meaningful parental leave, or we want to help provide educational opportunities.
Counsel, just to interject a bit here. I'm not yet persuaded on why everything you said still prevents this from going before a jury to make a determination about whether some of these statements on the website to a reasonable person would be misleading.
Sure. So again, puffery is an issue of law that courts routinely decide.
Not all these statements are puffery based on our back and forth. Some of them
Well,
are
I believe
goals.
they all are, but they're different type. There are different types of puffery. Some of them are extremely vague, ambiguous. Some of them are phrased as future goals or ethos, but I believe they're all puffery. But in any case, these statements are all of the type that like Pearson, where you had a lawyer suing a dry cleaner because he thought that they gave him back the wrong pair of pants and went to a trial over the word satisfaction guarantee that hung in the window, at the end of which the Superior Court and then this court held, no, that doesn't mean what he claims it means. That's puffery, citing all the classic puffery cases from around the country. It's a vague statement that's not capable of being measured. And that's really the issue, Your Honor. How is a jury going to measure?
So your argument is that our cases in this jurisdiction, like Meta and other cases, have found that where there's puffery as a matter of law, it is not actionable under the CPPA.
That is correct, Your Honor.
What if we disagree about whether this is puffery? Then what would be your next best argument?
Well, the statements don't pertain to goods or services. They pertain to Coca-Cola as a corporation and what its global goals and aspirations are. So, and obviously we agree that they don't have to physically appear on the package. A newspaper ad or a billboard is just as actionable as a label. So we never made that argument. But these statements about what Coca-Cola is doing as a company around the world to become a more sustainable business are not about goods being offered for services in the district any more than the Floyd versus Bank of America 1-800 or whatever the 10-digit number was, a representation about the bank's services, or would be a representation that we support a diverse workforce or anything along those lines. So that's the second major reason. The third major reason, Your Honor, is that the complaint here depends on this so-called mosaic theory, this combining this collection of statements that have appeared over a period of years in different contexts, whether on Coca-Cola's Twitter feed or in investor reports, annual reports about sustainability and ESG type filings, or on the website or anywhere else. That you need to combine all of this because the net impression of that amalgam of statements is one that Coca-Cola is somehow either, as they say, an unqualifiedly sustainable company today, or is doing more than it really is in fairness to address the problem of plastic waste. And we have cited a great deal of case law in our brief that holds that it is improper to aggregate statements like that because there's no reasonable expectation that a consumer would see all of those statements and would combine them in their own mind in that fashion.
Any District of Columbia Court of Appeals cases on that last point? I know you
That last
cited
point, Your
large
Honor, I
cases.
don't think we have a case on that, but I think you can look at the standing issue that we also raised and look at this court's decision in the Animal Defense League versus Hormel, because that raises a related issue. To have standing to bring this claim as a public interest organization under the CPPA, yes, the statute gives them standing by proxy, but they have to be able to identify a consumer or class of consumers in the district that could bring the case in their own right. That's one of the three prerequisites for public interest organization standing. And here we have argued, and we believe demonstrated, that there isn't such a consumer or class of consumers alleged or capable of being identified because these statements have been plucked from so many different places, and what the Superior called a bungle of disparate statements really exists only in Earth Island's complaint. So you would have to be somebody who is somehow miraculously exposed to all of these different statements, that they all register and create this overall impression in your mind as a consumer in order to suffer the injury that's alleged here, being deceived. And we don't think that they've plausibly alleged that such a consumer, let alone a class of consumers, exists. So we have, if you don't buy puffery, which was the primary reason the district court dismissed the complaint. And again, he referred to them as aspirational statements, as vague and unmeasurable, but that's all in my mind under the umbrella of puffery. You still have the fact that they're not related to goods or services being sold or offered for sale in the district, and that there's the so-called mosaic theory has been rejected by every court that's considered it, although I acknowledge that there's no case from this court that directly addresses that proposition.
All right, unless my colleagues have any additional questions. Thank you, counsel, for your
Thank you.
argument. All right, Ms. Wickland?
Thank you, Your Honor. And I would like to address a few things that have just been said, and then also the sustainable point. I think the argument that was just made does not actually agree with the text of the CPPA. If we look at the CPPA, by 3901C, what the CPPA establishes is an enforceable right to truthful information. That's it. That's specifically what's established. By 3905K1A, any consumer can bring an action to enforce that right to truthful information. By 3904, the right to bring an action for violation of the statute does not depend on whether any particular consumer is in fact misled, deceived, or damaged thereby. This is a very broad statute, and by the words of the statute itself, the focus is on the violation of the statute, which is the entry of misleading or untruthful information into the district. There is no requirement that we point to the person who saw all of these allegations. That's long been recognized. I would point to the Superior Court's decision in the equity residential management case, where the court said, well, there is this mosaic of representations out there. And, if you take this one away or you take that one away, the mosaic still exists. And that's what has caused this untruthful information to enter the district. So I think this argument that has just been made of, you have a responsibility to pull up a person and show us that that person saw all of this and how they understood it. No, that is not what this is about. This is an injunctive release case to stop information entering the district that creates this misleading impression. So that's point one. And I think that Your Honor made a good point. Where is the DC law on this? Or are we just citing statutes that are not put together the way the CPPA is put together? A lot of the briefs here, and particularly the amicus brief, said, basically, we don't like the way the CPPA is put together. And if you interpret the CPPA, there'll be too much litigation. That doesn't lie with this court, that lies with the legislature. We have the statute we have, and it clearly allows this action, as numerous decisions of the lower court have allowed actions like this. Then again, as to the point of sustainable, and this being just puffery, counsel mentioned several times the district court's decision in Bigelow T, which was not actually the word sustainable. I would point to the Superior Court's decision in a nonprofit case, TFUSA versus Aldi, which was a fish product, a salmon product with the word sustainable stamped on it. And what the lower court found was, well, actually sustainable does mean something. And I do think that sustainable means something. Even the UN has found something. There's a definition according to the UN. Sustainable meets the needs of the present without compromising the ability of future generations to meet their needs. And the allegation in the Aldi case was the way that this fish is farmed from an environmental perspective, this just cannot go on indefinitely. And so it's not sustainable. That did survive a motion to dismiss. A similar case, class action in Chicago, Rawson v. Aldi also said, you can bring an action on this phrase, sustainable. So then we get to the idea of, well, who can rely on this? And the Pearson case, which I brought up myself, the satisfaction guaranteed case. And I do want to point out, as counsel acknowledged, Pearson went to a trial. No one knocked that out. Those findings were made after a trial in which consumers stood up there and testified what satisfaction guaranteed meant to them.
And it wasn't, if I remember right, our holding wasn't that it meant nothing. It was that it might mean that if they lost your item of clothing, they pay for a replacement, or if you weren't happy with the dry cleaning, you have to pay for it. But it didn't mean that they needed to reimburse you $17 million or whatever number, because he's not satisfied short of that. That it didn't mean that, right? It was kind of a factual question at the end of the day.
That went to a trial. So, with regard to whether sustainable, which is not the only statement as we put out at issue here. And I do think that the words of the statute do allow us to consider these statements taken together. They've entered the district. But, the Pearson standard is that a reasonable DC consumer, just could not possibly rely on this. That's what gets you past the motion to dismiss. So what Coca-Cola is arguing is that a reasonable cola drinker within the District of Columbia could not possibly rely on Coca-Cola's assertion that it is taking responsibility for the packaging it introduces to markets, or that a reasonable DC consumer could not possibly rely on Coca-Cola's statement that it is taking a leadership position on the interconnected global challenges of packaging waste and climate change, much less that a reasonable consumer couldn't take all of these to mean what it seems to me, and I hope seems to you, Coca-Cola is saying about their efforts.
So I really want to try to nail this down, because if your complaint is unclear on what you think sustainability means, you've just brought forth apparently a definition that you're getting from some United Nations source. And it has no obvious meaning to me. But if the allegation were a reasonable consumer takes it to mean X, and that X, like in Bimbo Bakery, they said a reasonable consumer would take local to mean made within the state. That seems like a factual question to put to a jury. But contrary to what the 10th Circuit held in that case. But can you just nail it? Seems to me one thing that can't possibly go to the jury is, well, does Coca-Cola make itself seem a little bit better than it actually is in the area of sustainability? Because that really is just classic advertisement. So there needs to be, I feel like the word sustainability, you in your complaint need to lend it some concreteness. And if you got to a jury, would need to convince a jury that it means that concrete thing and that Coca-Cola's actions are incompatible with that concrete thing. Can you just one more time give me what you think that concrete thing is that sustainability means?
It could go on like it is.
It could go on like it is.
Sustainable.
And do you think you've alleged that in your complaint?
I do think that we have alleged that.
But by go on, you mean in perpetuity? What if it can go on for 100 years?
I think that would be an issue of fact to be proven in terms of what does the consumer think in terms of the length of time. But
well, sure, but what's the allegation? I mean, it might be a question of fact whether or not your allegations are true. But what's being alleged that sustainable? What's the allegation of what sustainability means? That
the allegation is that Coca-Cola is not being sustainable because it remains a major plastic polluter, that it's made no significant effort to transition to this circular economy, which is what it promises in terms of sustainability, this circular economy, and that it is not otherwise operating as a sustainable enterprise.
It feels very circular to me, the definition you're giving me of sustainability. Can you just, again, let's say that if this goes to a jury, jury question 1, does, as Earth Island Institute alleges, sustainability mean X to a reasonable consumer? And then question 2 is Coca-Cola's actual practices compatible with X? And have they alleged that they are sustainable, or have they advertised that they are sustainable? What's the X? What is the sustainability means what? And without that, it's just a very slippery case to me. And do you have a clear answer to what sustainability is that you can? What's your best answer that you think is fairly pled in the complaint?
I think that my best answer would be that sustainability, as Coca-Cola puts it, is this circular economy, so that when things are circular, it can go on that way. If we were to bring it to a jury and say, you know, and I'm not promising that this is the way we'll bring it to the jury. We haven't made that plan quite yet. You know, here's a graphic representation of the plastic pollution that Coca-Cola alone has put into the world this year. Here's a plastic, you know, here's a representation for next year's plastic pollution, you know. And here's how much of it is actually, you know, being taken care of. You know, can it go on this way? I think that would be a good way to prove it. Is that sustainable as you interpret the word sustainable to be? And so I would also like to talk about, you know, this goal where in these allegations, you know, there are these goals and Coca-Cola is saying, well, that can't possibly be a misrepresentation because they don't have a document showing that we don't mean to do that right now. But I would like to talk, what exactly is the pleading standard here? If we had the discovery and the documents in our hands, perhaps we would plead them, but that is the point. That's why we want to get to discovery. You know, it is actually pleaded in the complaint that Coca-Cola, as we pointed out, has a history of making promises to consumers and then breaking them. And we think that's what's going on right now, is promises being made to consumers so that they'll continue to buy the products, and that those promises, they don't have an intention of meeting them. But the pleading standard doesn't require us to already have the documents. And to
But
put
where's
those
the
documents-
allegation that they don't plan to hit the 50 and 100% mark? I didn't see that in the complaint. And I looked for it.
It may, you know, it may not be as specific as what Your Honor is looking for. We do plead that they have this history of consistently breaking
Yeah, I remember that.
these goals, and that they're not doing anything at this moment to address the immense problem of the, you know, of the plastic pollution.
I
So
mean,
that
I think Elon Musk promised to put a man on Mars by 2022. Maybe it was a woman on Mars. And now he's saying maybe 2026. I don't remember I don't doubt that is a sincere goal of his. I understand. I mean, quite frankly, I think there's no chance he's going to meet it. But it's, you know, entrepreneurs often make, you know, shoot for the stars, you might hit the moon kind of statements, where, you know, we set the benchmark high, because even if we fall short, we will have still made great progress toward that. It's kind of a classic, you know, I think you wouldn't want to set a benchmark too low. You kind of want something that's a little out of reach almost. Why is that? Why would a reasonable consumer think, well, if they've made significant progress toward that goal, and I don't see an allegation they haven't, that it's sort of an insincerely held one, which I take to be kind of the standard. It's almost a bad faith standard for aspirational goals. You don't really have that goal, or you're not really working toward it, or kind of the cases that I see on that.
But where is the limit there? If Elon Musk says, you know, I've created spaceships for your personal use, and you should buy them because I am in fact so good, I'm putting a guy on Mars by the end of this year, and you go out and buy a spaceship based on that promise. And then Elon Musk says, thank you for buying my spaceship. I'm not going to make it this year, but I've got a next generation personal spaceship, and it resembles the one with which I'm going to put a guy on Mars next year. Go and buy it. I do think that that is actionable. And I think that selling products based on making these promises, if you don't mean to fulfill the promises, I think that is a problem.
What's the difference between a promise and an aspiration here? Or promise, goal, aspiration, puffery? How do you draw the line? And because I assume you would say that these statements are not just mere puffery, which
I think that these are statements. You can take them separately. I think it's better and sanctioned by the statute to take them together, but that they do constitute promises to consumers that Coca-Cola is effectively addressing this problem. And I do think that, so this actually brings us around to the nexus point. You know, what is the nexus to the goods and services? I mean, just as a practical fact matter, Coca-Cola doesn't sell ham sandwiches. They sell beverages, many of which are in these plastic bottles. So what else do these representations relate to, if not their goods and services? But then I would point to the statute itself and the different categories under 3904, many of which don't mention goods and services, but instead mention a materiality standard. And, you know, materiality, as this court determined in the medical partners case, give me 1 second. Franklin versus District Hospital Partners, that was 2020 decision. You know, if a reasonable person would attach importance to the existence of the statement in determining its action, you know, then it's material, and the statute doesn't require a specific good and service, 3904F or F1 in that circumstance. And in that case, it was just a failure to mention something. It was a failure to mention that your surgery was going to be performed by a first-year medical associate. So I don't think it's a serious argument that there isn't a nexus in good to the goods and services here. And also Coca-Cola said, you know, of course, you know, they need not appear on the bottles, but no, the district or the Superior Court said they did need to appear on the bottles. So that's the decision that we're talking about here. And finally, I would encourage the court to resist Coca-Cola's effort to turn this into a policy dispute about recycling. Several times, I counted 4. Council said, well, Earth Island thinks this about recycling. Earth Island thinks that. You know, this is not a policy dispute about recycling. I will admit that I suspect Earth Island has a different opinion about recycling than Coca-Cola does, but this is really about what Coca-Cola is telling consumers in the district, how consumers would interpret that, and whether Coca-Cola is doing those things. They have a marketing department. They're making these representations to the consumers for some reason. And so the question is, can they be held accountable for that? Your Honor's made a lot of good examples about, you know, what can they be held accountable for? And maybe ultimately we won't be able to show that this is what consumers think about what they're saying and why they're saying it. But we do deserve the chance to get into court and make that proof.
All right. Thank you, Ms. Wicklund.
Thank you, Your Honor.
We thank all counsel. Oh, I'm sorry.
Oh, I wondered if we were.
Ms. Manziel, I don't think you reserved any time for, I'm sorry. I'd like to thank all counsel for your briefs and your arguments today, and the cases submitted. Right. Our second case this morning is Christian Green versus DC Child and Family Services Agency. And if counsel for the appellant could inform the court of how you and the amicus plan to divide up the argument.
Divide the time equally, 10 minutes each.
All right, thank you.
May it please the court, Douglas Hartnett for the appellant on behalf of Appellant Green, and I'd like to reserve 2 minutes.
All right, thank you, counsel.
In light of this court's decision in Holbrook, it is difficult for me to understand why there's any significant debate about whether the decision below can stand. Because Christian Green, who's here with us today, is exactly the kind of employee that the Whistleblower Protection Act was written for. The law is intended to protect employees who protect the public, and that is exactly what Christian Green did. As the Superior Court acknowledged in her decision dismissing the case, Kristen Green is a sincerely dedicated social worker who has spent her career protecting the district's children, not just children, but our most vulnerable children. Reviewing the Superior Court's oral ruling from the bench, it's understandable how between the lack of resources and the complexity of the child welfare laws that CFSA is charged with enforcing, that the court may have been blinded by the number of protected disclosures Green made and the sheer volume of material that she presented to her supervisors to support those disclosures. But that doesn't excuse the surface treatment the court gave to the elements of the claim and the affirmative defense. A comprehensive review of the record reveals that at every step of the way, Green was acting to protect children and was focused on her job duties of the ombudsman, which was to investigate claims of abuse, neglect, other violations by the agency. And she did so vigorously. While in contrast, her managers did nothing to verify the information that to verify or address the information that she presented, in some cases about child neglect, children that are in the care of the district.
Counsel,
Rather,
can I interject here to ask you to talk a little bit about this 6 specific disclosures that still remain on appeal. And the trial court's determination was that all 6 of these all the disclosures below were mere policy disagreements as to what the scope of the role of the ombudsman was under the statute on the Juvenile Youth Act. Forgive me if I'm not saying that.
Mostly Youth Amendment Act.
Juvenile Youth Amendment Act. How do you respond to that? Because there is some dispute, even on the part of Ms. Green initially, as to what the role of the ombudsman was. As she began the role performing it one way and then interpreted the statute to mean that she should be interpreting it a different way. And it seems that the agency general counsel didn't agree with that interpretation. So how do you get beyond this being just a dispute about policy and how what was required under the statute of the ombudsman and what her disclosures actually were?
Well, the first thing I would say is that a policy dispute or not is irrelevant to whether the disclosures were protected. What happened in this case is that Chris Green was assigned as the ombudsman. She looked at the FYAA and said, hey, wait a minute, there are problems here. We're not doing the things that are in the statute. She went to her bosses and said, hey, I'm the ombudsman. I'm the designated mechanism to receive complaints and do these investigations and implement the accountability in the FYAA. And it's not happened. So I want to change my position, or she made some suggestions about how to improve her ability to do that. Her supervisors disagreed. But the reason she did so, or the method by which she did so, was she presented information about investigations that she found and found wrongdoing and said, these things need to be addressed, they need to be reported, and we're not doing it. Classic, very concrete example, 2 things that she found out immediately was that they weren't reporting this, complaints from 2/3 of the population. Only 15 and above were prior to Green's tenure as the ombudsman. They didn't report violations that came to the, and second one, they weren't distributing records as required by the statute. And as you can tell from the record, there's a big dispute about what they're required to report in the annual report. But again, that's not what they're required to report in the annual report, has no bearing on whether the disclosures she made were protected. The only bearing is whether she had a reasonable belief that they evidenced one of the protected categories in the statute, gross mismanagement, abuse of authority.
Well, isn't it also a question what the district argues that some of these alleged disclosures were minimal? Like I think the one about this social worker providing information records to people under the FYAA.
Well, Your Honor, I would posit that if I was the child who didn't get medical records that I need, that's not a minimal violation for me. I would argue that the ignoring complaints from 2/3 of the population when the statute was intended to create some sort of accountability for the CFSA. This is an agency that was under court supervision for over 30 years. The council passed the FYA to create some accountability. And if you want to look at the overall context of this whole case, as I'm sure my colleague in the amicus will allude to, the council acted on Chris Green's disclosures. CFSA fired her.
When you
And
say
if
the
you-
council acted on Ms. Green's disclosures, are you referring to
The statute that they
amended
passed.
statute?
completely
that was-
reforming-
in
the
terms of the
conference was-
timing, I may be
was a-
mistaken. I thought that was after Ms. Green was let go.
Yes, it was. Yeah. Yeah, but in the aftermath of all the disclosures she's made and her case in her whistleblower claims, and in fact, I mean, she was not an employee who was shy. She was in contact with council members. She was in contact with the court monitor. She was in contact with the DC auditor.
Let me, I guess, shift to another area of our analysis here. If we were to agree that the disclosures were protected disclosures under the Whistleblower Protection Act, how do we address some of the other issues in the case? Whether or not there was a nexus between those disclosures and Ms. Green's firing. And I think CFSA would point us to performance issues on the part of Ms. Green.
Well, that's
Her specifically her writing style, her communication style, and insubordination,
right,
I
right,
think are the allegations.
right,
How do we weigh those?
right. Well, I
If
would,
we agree with those, and does that then would sever the nexus?
yeah, well, no, I don't agree that there's any problem with Nexus. First of all, the disclosures that she made, she repeated over the course of time, first to this general counsel, then to the director of the agency, and then again in the report that she was charged with writing at the end of the year. Ironically, Your Honor, what the dynamic of what happened here is Green made disclosures to her bosses. They ignored them. She made them to the director. They ignored them. She wrote them up in the report. They removed them. She put them back in the report and asked the director to choose which version should be used, and they fired her. I mean, they actually fired her for protected activity, and they're asking this court to endorse explicit termination for protected. They say it's insubordination to put those disclosures back in the report. It's
Well, I mean,
protected activity.
it might be. I mean, what if one of my employees decided to put, one of my
Well-
clerks drafts an opinion
You're right.
and they disclose a variety of grievances they have with me.
Mhm.
And I say, whatever your grievances with me, those don't belong in an opinion. This is not what opinions are for. Take it out. And they go ahead and they put it back in and they take it up to the chief and they say, Chief, yeah, I have some grievances with Judge Deal. These really should go out in the opinion. And I end up firing that employee. Wouldn't the reasonable inference be that it was for insubordination, not for the disclosures themselves? They're putting it in places where it doesn't belong. And isn't that roughly what the affirmative defense is here, Miss Green? We've heard your complaints and there's been no action taken against you after you voiced them multiple times. But you, as ombudsman, it's not for you to put these in your report. That's not what this report is for. You're a go-between for reporting, and you're acting outside in your professional duties. You're doing things that you are not tasked with.
Okay.
Why isn't, I mean, that's what I understand the affirmative defense to be. And what in the evidence do you think gets around that affirmative defense?
Well, first of all, the direct connection of the disclosures, this is in this context, she was trying to publish the disclosures, which is required, and the council had advised the director they were waiting for this report. So it's not just a matter of, oh, we can't do this here. It's a matter of she's trying to get the information out and they're refusing to do so. The question would be for the jury. It's a question of contributing factor, which is an extremely low standard, first of all. And second of all, on the affirmative defense, they have to prove by clear and convincing evidence that her attempting to make these disclosures was not a contributing factor to the decision to terminate her. And I think that certainly we have a question back on the record for that.
Well, I think the district says we don't. And I think their argument is, look, these disclosures have been going on for a while. And there had been a lot of clarity with Ms. Green that she was overstepping the bounds of her employment. The disclosures themselves weren't the problem. And you can tell that by the fact that we took no action against her until she kept at it, until what she was doing it was a deviation from what she was employed to do in the district's view. Why don't, I mean, why don't the facts sort of point squarely to that conclusion?
Well, first of all, the district makes allegations she was insubordinate throughout the complaint for a long time before, on the verge of publishing the report, they fire her. So there's a culminate, there's a building up of the activity here. And she's free to go beyond her duty and make disclosures about wrongdoing. That is protected activity.
Sure, but not in a report that comes up under the agency's name, right? This isn't a letter to, you know, a DC council person. This isn't a letter to the Washington Post. This is an official report, and they're telling her it doesn't belong in there.
Again,
You know, I mean, again, it's my clerk putting my own faults in an opinion.
Mhm.
That might be a protected disclosure. That might be something that they're allowed to run up the flagpole in some way.
mhm.
They don't get to put in an opinion, and if they try doing it after I've warned them a couple of times, they're gonna get fired.
Well, they never warned her, first of all. They never said anything about firing her until she received her
Well, but they
termination
did,
letter. A month before.
tell her to take the information out. I'm sorry, they did repeatedly edit the report to take out some of the information that was of concern and discussed other ways to summarize the information, to report it as a trend,
Mhm.
as the agency interpreted the statutory requirement.
I would say that obviously the standard is clear and convincing, and so it's a question for the jury here. But secondly, that completely lost my train of thought.
It happens sometimes to the best of us.
If you repeat the question.
Ms.
Oh,
Green was
I'm sorry,
repeatedly, yes.
Yeah, there were two rounds. She drafted it. They said no. She went back and put them in and said, I think these things are important. But what she did was say this, and the director asked her to create this combined report in a meeting on March 3rd. So they had a meeting and they all discussed it, and the director said, I need to see both versions. So I don't think there's any real basis to assume that you know, that they considered it insubordination at that time. Until.
Well, I think the insubordination claim, as I read the record, seems to have been building. That there were some challenges editing.
There was some dispute about the information that she was collecting.
And the manner in which it was written. So there were significant edits, I think,
Right.
to the style
Right.
and
Well, if you look,
resistance to some of the edits.
Yeah.
And so it doesn't seem like the one instance
Mhm.
at the presentation of the two reports is the only thing. There seemed to have
No.
been a runway up to that.
No, I appreciate that. And what I would say is that in response to each of the challenges which the district says were insubordination, she responded that with a reasonable explanation of why she was resisting. For example, her job is to collect complaints from individuals about agency misconduct. And that when the agency said, you have to turn all the information you get over about who the complainants are, what they called about, whatever, you have to turn that over to the general counsel of the agency. Of course, we'll be defending the agency in any kind of lawsuit that might result from the investigation. And Green said, I don't know if that works. And I don't think it's compatible with the FYIE, the accountability statute for the agency. So I'm not saying that she was wrong. And she also said, I will do it at every turn, except for the disclosures in the trend report. But she didn't get a chance. They fired her before that. But she accepted, you know, she protested at first, but accepted all the directives that they gave her in the long run.
I ask you about the temporal proximity issue.
Right.
We do have some case law that says there needs to be some proximity between the Whistleblower Act and the firing or other adverse action. And here we have significant amount of time, arguably.
We do have a
And we have cases that seem to suggest that the timeline here may be outside of the timeline where we've
right.
drawn that temporal connection in the past.
Right. Well, there are all sorts of, agents, the defendants are quite fond of saying there's a bright line test for the sort of temporal proximity. And the fact is there isn't. Temporal proximity is very powerful. If it's close, it's not very powerful, it's far. But it's only one element. And here we have repeated disclosures, repeating the same information over and over again over a period of about approximately 8 months, I think it was, and culminating with attempting to publish them to the public in the disclosure. So they were talking about these disclosures from day one through the end of the period of this claim. So there isn't any question that her disclosures were in the manager's minds from day one.
Unless we have any additional questions from my colleagues, you can reserve the remainder of your time for rebuttal, and we'll hear from counsel for the amicus. Thank you.
May it please the court. My name is Tom Devine. I'm counsel for the amicus. In nearly 45 years of working with whistleblowers, I've never before encountered a whistleblower whose disclosures were so powerful and well taken that the legislature unanimously passed a law abolishing the duties of the agency whose alleged misconduct the whistleblower was challenging, created a new remedial structure, and added in additional whistleblower protections in the process. Yet somehow that was not deemed to be protected activity by the trial court. And that conclusion only could be reached by failing to respect plain statutory language,
Mr. Devine,
elementary rules of statutory construction.
can I ask a question? Because I was curious. I want to hear you talk more about the amended statute and the implications of it, because could we also interpret the fact that council amended the statute after this incident to mean that the statute wasn't clear in making the kinds of disclosures that Ms. Green made protected disclosures, and therefore they needed to amend the statute to make that more clear? Or is there a different way that you would interpret the amended statute?
Well, of course, we could speculate on why the council passed the law. I think a preferable hypothesis would be that they thought that this agency wasn't enforcing the law as the council had directed it to, and their abuses were so severe that they weren't going to give them another chance and just further guidance. They're going to take away the duties from them. But even if it wasn't a matter of illegality, if the council took actions because they thought there were abuses of authority or substantial and specific dangers to public health and safety that were not being addressed by current law, that would qualify as protected activity also. But the trial court's decision also relied on the wrong generation of the Federal Whistleblower Protection Act and the DC Whistleblower Protection Act, which it was relying on for authority. Let's go to the first argument. And basically it can be summarized as the failure to accept that any means any. There are no loopholes in the DC Whistleblower Protection Act, except where there is a specific statutory prohibition. Otherwise, if you have a reasonable belief, you are eligible.
So when you refer to the trial court relying on the wrong generation of whistleblower cases,
yes, ma'am.
are you saying that it was incorrect for the trial judge to rely on this notion of public policy or policy dispute versus disclosure? Because I think here the trial judge found that these statements really evidenced a policy dispute about the role of the ombudsman and not protected disclosures. Is that part of the old outdated scheme, relying on something as being a matter of policy, or were there other ways that the trial judge's analysis was outdated?
Your Honor, I don't think in any generation of the Whistleblower Protection Act, you're going to find a policy loophole. However, in the 2012 Whistleblower Protection Enhancement Act, which considered the distinction between policy dissent and whistleblowing, in 5 U.S.C. 2302 A2 capital D, Congress explained that while you're not protected against retaliation just for disagreeing with a policy, you are protected if you're disclosing the consequences of that policy, and the consequences could be illegality or abuse of authority or threats to public health or safety. That's why I think this court in Holbrook distinguished that it's not a mere disagreement when your side of the disagreement is to disclose what a jury could conceive of as being illegal. The trial court below said that there was a problem with protected speech because the information was in an attachment, because Ms. Green didn't identify herself as a whistleblower, in addition to policy. And of course, Your Honor raised the question of what can you do this in an official report to the city council, as opposed to just a letter to the city council or a press conference or something like that. There is no loophole for attachments. There's no loophole for branding yourself as a whistleblower.
But the point is
There's
not
no-
that there's a loophole.
I'm sorry,
But my question was not getting at, is there a loophole in the statute? My question is getting at, in that instance, isn't the obvious reason for termination not the whistleblowing, but the manner in which it's being disclosed? With the example I gave being the law clerk trying to put it in an opinion, which would be, I think, wildly inappropriate. And that the evidence here might support a view that it was outside of her role as ombudsperson in writing this report to put those disclosures in there. And the fact that she had made them previously, this doesn't really get to your statutory argument, it gets to the affirmative defense. But why isn't the more natural inference that it wasn't a problem with the whistleblowing? Maybe it's summary judgment, so maybe this is not a natural inference for us to make right now, but why isn't the more natural inference that it really goes to a dispute about what her job duties are and not about the content of her disclosures, which she was otherwise free to make through appropriate channels?
Your Honor, the statute is very explicit. There are no exceptions based on context, forum, or whether or not it's part of your ordinary job duties. The only thing that matters is that you're lawfully communicating information which you reasonably believe is evidence of illegality or some other significant.
Right, but
public health
you would have an affirmative defense that they've disclosed it in a manner that warranted firing, that warranted termination. And it wasn't the disclosure that we cared about, it was the manner in which it was conveyed. That would be a valid defense for the district has raised that defense.
I don't think that would be, Your Honor, because it would have to be something in the statute which says, except in this context or except in this circumstance. The statute is clear. It doesn't matter.
No, that's a really wild theory. So let's say I work for the district and I have access to their website and I take down the entire DC government website and I post a series of grievances with things that I think the district is doing illegally. I've voiced all those disagreements before to no avail. And they say, well, now we're firing you because you hijacked the website. Clearly something you weren't entitled to do and you're out the door. You think if those were the facts, there would be no defense to that termination?
If there were a statutory prohibition on posting on the website, it wouldn't be protected activity.
I'm not talking about a statutory prohibition, just, hey, employees, we have a webmaster who runs the website. Don't hijack our website and post disclosures up there. That's the policy. I assume the district, like most companies, has a policy like that. Freewheeling employees aren't allowed to hijack the website and post whatever they want. And in this case that I'm positing, the employee did. You think the fact that the thing they posted was a protected disclosure would preclude that being an affirmative defense for their dismissal?
Absolutely, Your Honor. I think your concern is that maybe the statute is too wild, but the statute says there's only one exception, a statutory prohibition. If you're not covered by that exception, then the test is whether you had a reasonable belief that you're communicating significant misconduct.
Yeah, I suppose I'm kind of asking about the contributing factor question. Which I don't hear you really, maybe you just don't want to engage with that because as amicus, that's not your primary concern. Is that, but you would still need to show that it's a contributing factor to the termination, right?
I'm sorry, sir.
You would still need to show that the protected disclosure is a contributing factor to the termination.
Oh, yes, sir.
And if they could
Absolutely.
say, and if it were clear that it wasn't because it was the hijacking of the website that was the problem, then you would be entitled to judgment as a matter of law.
Well, the case law interpreting whistleblowers is pretty clear that if it's protected activity, but you've got some other right connected with the protected activity, that the protected activity prevails. It doesn't matter if it's one of the key cases in the Whistleblower Protection Act was Whitmore versus Department of Labor, where the whistleblower was quite offensive in how he communicated his information, his concerns. But that wasn't canceling out the fact that he had communicated protected information. And indeed, the statute says that you're explicitly covered as communicating information in the ordinary course of your job duties. And Ms. Green had a reasonable belief that her job duties legally required her to communicate with the city council. And that's consistent with the statutory language in this law. It's actually a violation of the law to try and obstruct any communications with the city council, whether they're in official reports or private phone calls. And she thought that that was her duty. So the fact that it was in a report as opposed to a letter or testimony is just not relevant in terms of statutory language, Your Honor. The next area that we feel that exists besides violating plain statutory language is adding an exception. Since Rossello versus the United States, the Supreme Court law has been very clear that a court cannot add exceptions if a legislature has already made some. And here the legislature did make an exception with respect to only prohibiting disclosures of information which was barred by statute. The other area that I think is extremely significant is that the trial judge said that the information had to be beyond debate, that it couldn't be debatable. That was a standard which was court decisions for federal law before 2012. And in 2012, Congress explicitly overruled the non-debatable standard, which had come out of the LaChance v. White case, and said basically the statutory definition is if it is debatable, if people having the same knowledge could agree with you that it's protected speech. And that's consistent with statutory language, which only requires a reasonable belief. The statute doesn't require you to be right, only a reasonable belief. And that's why mistaken disclosures can be protected against retaliation. A whistleblower is only a witness and is not required to have the same degree of certainty that a court would after legal proceedings. The third concern that we had is that the trial judge said that asking to blow the whistle did not trigger her rights. Actually, asking to blow the whistle, she made a disclosure as part of her ordinary course of duties to seek permission, and she disclosed the same information that she wanted to present to the city council. That made it protected activity. And the case law under the Whistleblower Protection Act is very clear that when you ask for permission to blow the whistle, you are perceived as being a whistleblower, and subsequent retaliation is illegal.
Now, we
violation of
haven't
the act.
explicitly adopted that perceived to be a whistleblower doctrine in the District of Columbia yet. I understand that may be a doctrine under the federal statute.
It's in the statutory language of the DC Whistleblower Protection Act that if you're perceived to be a whistleblower, it's illegal to retaliate against you.
And have we had any cases on that issue yet before here?
I've had some on the federal level, the civil service, but not in DC, Your Honor. We think that those three errors are just dispositive here. And finally, in underview, if this court feels that Ms. Green did engage in protected activity, it's not necessary to merely remand the case. We think that the appropriate action would be to reverse because the other categories are almost impossible for the agency to win on under the current record.
Well, if we find that there was a protected disclosure that she made, don't we still have to go to the next step of determining whether her firing was connected to that disclosure?
Yes, Your Honor, and I think the record already is dispositive on those issues. There's no dispute that the agency had knowledge of her disclosures. That's the second element. The third element is contributing factor. The district erroneously said that there was a 7-month time lag when there was several weeks after her last activity that was protected. But the case law since 1993 in Schnell versus Department of Agriculture has been that the time lag for establishing contributing factor is 1 to 2 years, not less than 7 months. Then you get to independent justification. There's 3 factors for independent justification: strength of the merits, motive to retaliate, and disparate treatment. Disparate treatment can't be relevant here because there was no comparator. The motive to retaliate was extreme by the DC government, and well taken motive to retaliate. The city council agreed with Ms. Green. Then you get to what's their merits. The nature of the charges against her is that she was being insubordinate because she objected to and kept trying to make whistleblowing disclosures. In the Holbrook decision, this court explicitly rejected that as an independent defense. They said if you're objecting to or not cooperating with misconduct, that's protected activity. It's not independent grounds to fire you for being insubordinate. We think that this is a very clear case of how the Whistleblower Protection Act was designed to be implemented.
All right, thank you, counsel.
Thank you.
Ms. Johnson?
Good morning. May it please the court, Holly Johnson for the District of Columbia. I think it would be helpful to clarify. Also, I believe my time is 20 minutes. Thank you. I think it would be helpful to start by clarifying what is actually before this court, what's been preserved in this case, because the record is so huge and it would be really helpful. There's 3 principles of forfeiture at play here that will really help narrow the issues before the court. The first was set forth in the 2020 Johnson decision at note 5. Only the disclosures argued as protected disclosures in the opening brief should be considered. There are 18 of those, and they are identified in my opening brief. Everything that Ms. Green argued was a protected disclosure is set forth there. The second is that after the opening brief, the plaintiff is locked into the types of misconduct alleged. So the Holbrook decision at note 2 holds for that principle of waiver. And that's important here because as we're hearing now, there are claims about substantial and specific, I can't say that, substantial and specific danger to public safety. That's not argued in the opening brief. In the reply brief, Green suggests all of these things could be gross mismanagement. That's not argued in the opening brief. The third principle of forfeiture comes into play only under the type of misconduct that's a violation of a law or contract that's not merely technical or minimal. And in Poindexter, this court strongly indicated that at litigation, the plaintiff has to identify the law, the specific provision. She doesn't have to do it at the point that she's making the disclosure. And no one would expect that of an employee. But when they have a lawyer and they're in court and they're saying, I reasonably believed this was a violation of law, they have to say what the law was, because otherwise it would require pure speculation as to whether that was a reasonable belief. So with those principles in mind, I want to begin.
Can I interrupt just on that
Of
question?
course.
And forgive me if I'm missing something, but are you no longer arguing that the waiver that arises from the trial court's comment about everything being incorporated, the district's arguments being incorporated? Do you know what I mean?
We
Yeah.
absolutely stand by our forfeiture argument. I can answer questions about it if you want to. I understand the trial court's decision was not entirely clear. I might not have made the forfeiture argument had it not been for Ms. Green placing that as an issue in her opening brief. She presented as an issue before the court and considered forth no argument. I'm happy to rest on the briefs on that. We do think that argument prevails and in fact would resolve the entire case. But I would prefer with the limited time here to deal with the merits of the same action defense, which is where I would like to turn to. I think this is very important. For a year of Ms. Green in the ombudsman position, she campaigned for more authority and she wouldn't take no for an answer. And there was a final decision email issued with regard to those questions after the March 17th meeting, I believe in early April, on JA 381 to 82, the director issued, and in quote, final decision. This is the director's final decision on the 3 policy issues that were in dispute. And Green's response on JA 377 to 79 is not okay. It's not I will comply. It's another round of the same arguments. And again, saying I will comply if you give me a formal written decision by the general counsel. And even then I will not comply unless you change my title to something other than ombudsman. She suggested being called a complaint line. She never said she would comply and she never did comply. So what I would urge this court when we're dealing with the same action defense, and I do want to get into the merits of that, but I would encourage this court to listen to the audio of the March 7th meeting. To listen to the audio of that so you understand what was really at issue there. That's the meeting where they're talking about the report, but really the meeting didn't talk that much about the report because Green kept bringing up the policy disputes. That's what she wanted to talk about in the meeting. Then the final decision that I've given you the cites for and Green's response, because that was the last straw. The reason for her termination as set forth in all 3 of the supervisor's testimony was that she would not accept the limitations on her role. Now it is important because I think that the argument preceding this has assumed that her discussions regarding the role of ombudsman were protected disclosures, but they weren't. And she conceded that at her brief on page 17, she admitted that she conceded in the trial court.
Let me just probe this argument a little further, because I think we set aside this policy debate for a second and we look at the disclosures. You know, Ms. Green wanted to enumerate the areas of non-compliance. She was told in different ways not to, essentially. She wanted to include it in her report on trends and findings that the ombudsman, that's required under the statute. And those were edited out. What, I guess, what policy decision supported the agency's view that complaints about the agency's compliance with the statute shouldn't be included in the report?
I'm really glad you asked that question because I want to
Thank you.
emphasize.
I look forward to your answer.
I'm so sorry. Was that sucking up? I'm sorry. I want to clarify the record on this. Her supervisors never said you can't disclose that misconduct. They said, we need to see the underlying data. We need to know why you think this is a systemic trend or issue. And Green deliberately withheld the 2016
Well,
data.
I don't know if this goes to the point about the intake forms that she was asked to use. And her response was, well, if we make people fill out these intake forms, then they have less confidence that their complaints will be taken seriously and confidentially.
So as soon as she said that, and by the way, that was more than 6 months before her termination. As soon as that issue came up, the General Counsel Chandler, now Magistrate Judge Chandler, said, great, let's redact, let's take the names out. There's ways, I mean, this is a child services agency. They know how to protect the identity of complainants. And they said they would take care of that problem. That wasn't the issue. The issue was that Green would not use the intake form at all. And if you listen to, again, the meeting on March 7, you can hear the conversation where she's saying, no, it's a systemic problem. I can't use the intake form. And basically, and she didn't say I won't do it. She said, I'll comply if you put something in writing to say it's legal. And if you change my title, and then she threatened, and I'm going to get you a record site on this because I think this is important. Oh, okay. So there was a conversation on in October of 2016. And there was an email chain that starts on, and this is also in response to, I believe, a misstatement of fact in the reply that I wanted to address as well. So I'm going to back up and start there, but I will get to the point you were talking about. Okay, so she refused to use this intake form. And in the reply brief, Green claims that she did comply with that on 10/21, and she cites JA 69, which is Green's affidavit. But if you look at the actual record, not Green's affidavit, but the documents in the record, you can see that the email she was saying, or that she's now saying, said she complied with the intake form, was her response saying, here is an example of a monthly report, not the intake form. Here's an example of a monthly report I could use. She never did the monthly reports. That's clear from the March 7 meeting when there's a discussion about that. Has nothing to do with the intake form, but also then on JA 224, a week later, she sent an email that said, I will comply with the intake form if I get a written legal opinion from the general counsel. And then in that email, she threatens to poison the well. She says, but then I'm going to have to explain to everyone who complains that I'm not going to be personally investigating, that there's a new intake form process, and the potential resolutions will be different so that they may determine their course of action. So she never used the intake form, and she was ordered to do so. She never supplied the monthly reports, and she was ordered to do so. But I think most importantly, when we start talking about the annual report, she wouldn't disclose the 2016 data. In her email to Jufrost, and this is on SA 235, she said, and this was way back in early January, she said that her supervisors wanted access to all her data, but that she was going to withhold it so she could, and the sentence is hard to parse out, but basically what she's saying is, I want to logically corner them into inaction so that they have to accept my office for more authority. Like she basically was saying she was going to withhold it. And then there's more emails about this.
Well, there is a quote, and I'm trying to find it, where she alleges that the general counsel told her that she needed to do more off the paper or fly above the paper. What is that? Seeming to imply that she shouldn't be documenting some.
I apologize.
something.
I've gone through, if you can point me to the record, that
I
would be
mean, I'm
helpful.
gonna
It's certainly
find
not-
that as you talk, so.
It's certainly not something from the opening brief. So I do want to mention this though, because I think it's important, the 2016 data. She's ordered to provide that data. She admits she's ordered to provide that data. If you look at, I'm sorry, JA 203 is her January email to Jufrost. That's when she sort of explains her plan to use that data as leverage so that she gets to write the report she wants. And what she said she wanted to do in writing the report she wants is to have the office have the agency accept the office for the level of authority that she wanted. Then at SA 235, this is a March 14th, so this is after the March 7 meeting, she tells Jufrost that the chief of staff Josephs wants access to all of her data, that she gave her the 2017 data, but was struggling to give her the 2016 data because she was worried about handing it over. And then in her email to the court monitor, a couple days after her termination, she says that she has not given them the 2016 data because she wants them to have to acknowledge to the council that they do not have access to the raw ombudsman data from 2016, thus would be unable to validate the information. This is the information in the annual report, resulting in no trend report. She was withholding so when she says that the supervisors didn't want her to release information about agency misconduct, she never gave them a reason. And this is critically important. If we start talking about the disclosures within the report, she's also given this court or a jury no reason to think that that information needed to be in the report. To make a protected disclosure, you have to disclose the facts, not to make it, but to prove that you reasonably believed in your disclosure at trial. You have to disclose the facts on which your disclosure was based. You have
Can
to
you
give the information.
clarify
I
something
apologize.
for me? And I'm, again, I might be misunderstanding something, but it seems like I don't think anyone's really disagreeing that she was insubordinate. There's some confusion over, or the question is whether, one of the questions is whether she was fired for that or fired for protected disclosures. If we found that there was some kind, some kind of protected activity here. How do you, it seems so intertwined, how do you determine that she was fired only for insubordination if it seems like the same activity?
So this is, I'm gonna start by talking about this court's case law, because I think that's important. This court has never adopted this CAR test that the federal court adopts, and I think for good reason. The federal court generally sees these cases after they're reviewing for substantial evidence. The CAR test is a test after a hearing for substantial evidence. That's the test that's applied. What this court applies is a summary judgment standard that was first set forth in the 2007 Johnson decision, but has been continued to be applied in recent years, even after the Whistleblower Act was amended. Most recently in Kalowski, where in that case, the director of the agency said he fired the head of the DNA lab for giving him the wrong data. And the plaintiff admitted that he'd given him the wrong data. He had some disputes about whether it mattered. He had some disputes about whether that was it was on the right day. But he admitted that in the same misconduct. And this court said, even if the supervisor had overreacted, the courts shouldn't second guess the business judgment of the supervisors. Now here, Green admitted to Meltzer after the fact that she engaged in the misconduct for which she was terminated. And there's plenty of evidence that all three supervisors testified that the reason she was terminated is because she would not conform to the role as the agency had defined it. That's all you need for summary judgment.
Although that's not really, that wasn't really the trial court's basis for granting summary judgment here, was it? I thought that the basis was there were no protected disclosures.
Certainly the trial court, I'm sorry, go ahead.
It's okay. Let me just flesh out the thought though. It's a little awkward for us now, and really quite cumbersome to do what is effectively the job of a trial court in the first instance to say, well, let's say that's wrong. Let's say that there are some protected disclosures. It might be right that the evidence is pretty clear that Ms. Green, there was an independent reason to terminate her, and that there's no real likelihood that the protected disclosures were a contributing factor to her termination. This is a very fact-intensive inquiry, though, and it's a fact-intensive inquiry that the trial court just skipped. Why should we? I think it's a discretionary call whether or not we want to dive into that on our own or send it back for the trial court's consideration. Why should we get into that? It seems like I know it's summary judgment standard. We can do it as a matter of life, but no doubt we can do it. But so far in your 15 minutes today, it's been a deep dive into record evidence that I guess we could parse through. It's sure nice when the trial court does that in the first instance, though. It makes our job a lot easier. Why not give it a chance to do that?
Well, I think especially in this case, it would be a waste of judicial resources overall, because this would go to a new trial judge. Judge Penn is no longer in the Superior Court. So this would be going to, and the Superior Court record is massive and unwieldy. And this would be going to a new judge for a question that frankly, the court almost always reaches the alternative argument. It's very rare for this court to remand back for more trial court opinion on summary judgment. And yet, especially in whistleblower cases, often the trial court stops after protected disclosure. I will also note that the trial judge was right about the protected disclosures. I would love to argue for a moment and explain to you why Ms. Green didn't actually make any protected disclosures. She has not met her burden of proving reasonable belief in any of the disclosures.
What about the failure to disclose the information to the discharged juveniles? Where I think your argument is that was just a minimal violation of the law.
No, that's sort of my argument,
Okay.
but perhaps not quite as close, because my argument is that, sorry, I want to find it because I think it's important that I have my notes on this one. Oh, yeah, okay. First of all, there's two issues, and the only one that's before the court is the one that came out in the opening brief, and they're conflated in the reply brief. So I just wanted to clarify that the question of disclosing records to the juvenile youth is different from this question in the reply brief at 15, talking about failure to inform youth of their rights. That's not in the opening brief. That's not before the court. Now, here's the problem with her claim, and it's just a claim that's, I believe, within the draft report. And so she did articulate it in her opening brief that at times they failed to disclose but she doesn't say what records were withheld. She said that complete records required under the law were not submitted. So we don't know, like for example, one of them in the statute says that it needs to be like an original copy of something. Maybe it was just a photocopy of it. Maybe it only happened once. Maybe it was, we don't know any of that because she hasn't put in any of the underlying data. Beyond that, even if the court weren't concerned about whether it was a minimal or technical violation, we don't know why she thinks that happened. And I would refer this court to Freeman, where it said it is a plaintiff's burden not only to prove that they reasonably believed that what they disclosed rose to the level of misconduct, but they have a burden of proving that they had a reason to believe that what they disclosed actually took place. And she has offered no reason. We don't know if she heard this as a rumor. We don't know if some child said this. We don't know if the social workers admitted it. She hasn't met her burden. And that was one of the reasons I'd like to spend a minute if possible. Sorry, go on.
I want to take you back to one of the specific disclosures. Judge Steele's asked you about one regarding the giving of the records to the juveniles, back to the juveniles. I had asked you a moment ago about a certain quote that troubled me, if it's accurate, and it's at, I think, Joint Appendix at 065, and it's in the private meeting between Ms. Green and General Counsel Chandler on September 15th, 2016, where Ms. Green is discussing the ways in which the Ombudsman's office would enforce the FYAA, specifically the reporting of outcomes as required by law. And Ms. Green states that an outcome would result from, for example, of an investigation where the Ombudsman may investigate an incident or complaint that would not be on the radars of other agencies like the Metropolitan Police Department or Child Protective Services.
I'm so sorry. I want to make sure I'm following in the right place, and I don't know if I have your spot.
Sorry.
You're on the Joint Appendix 65?
Yes, 065.
And which in paragraph 66?
I just have that
I'm so sorry.
citation in my notes, so. In response, General Counsel Chandler told Ms. Green, allegedly, if I'm quoting this correctly, to lift, quote, lift off paper,
Oh, I see.
meaning to forgo formal records or written findings.
Oh, I don't, okay. I don't know to what extent this was argued as a protected disclosure in the opening brief. I certainly didn't see it, but I can also say, I mean, I don't think this is an issue anywhere in litigation. In response to me raising these issues, I was often told, she's not saying she was told by Chandler to lift this off paper. She's saying, she doesn't say by who she was told, which was internal CFSA terminology, meaning not to formally record or have a written record of findings. Well, we can talk about findings. I'm fine with that. I will note that findings is not one of the disclosures that's protected disclosures.
Or the lift off paper, because that seems to suggest to me that she's being told, if I was mistaken that it was Ms. Chandler, forgive me, but she's being told by someone at CFSA to quote unquote lift off paper, which seems to me to suggest she's being told not to record, not to write down, not to report.
Well,
certain things.
I mean, I'm only responding to what I'm reading here because this was not an argument I realized was properly presented. So I haven't, but the way I'm reading this is she says, in response to me raising these issues, I was often told, so she's not talking about her conversation with Chandler, to lift off paper, which was internal CFSA terminology, meaning to not formally record or have a written record of findings. And this findings issue was one of the issues that is part of the policy disputes regarding what the ombudsman should do. She wanted to issue formal findings, your rights have been violated findings, and the agency did not want her to do that. Nothing in the statute suggests that she should be required to do that. And none of that is before the court in the protected disclosures that she identified. I just don't think that her affidavit that doesn't clarify who told her that or when, or I just don't think it's sufficient here. I'll also note while we're talking about her affidavit, because this is really important, Green's brief and reply brief almost exclusively cite to her affidavit instead of the actual record. And many of the things in her affidavit do not accurately reflect what is in the record as the actual communication. So, for example, in Green's reply brief, she asks you to go through several pages. She still in her reply brief doesn't say what it was in the report, which of the hundreds of changes rendered it non-compliant. I think that she's forfeited any argument that the report was not compliant with the FYAA by that. But in the reply brief says, oh, just look at these 5 pages of Green's affidavit. And when you start lining up those claims in her affidavit with the blue and green text in that combined report, which is the controlling document for what she wanted to put in the report, they don't always match. Sometimes what she says was stripped out of the report is actually in the report. It's just in different ways. For example, she says that her supervisor stripped out of the report any claim that the year before CFSA was underreporting because they weren't reporting claims made by people under 15. But that's in the report. It's in there in footnote 1. So I just think, unfortunately, when dealing with the reply brief, which contains misstatements of the record, that this court needs to track from what the reply brief cites back to the affidavit, see what Ms. Green is talking about, and then look at the actual record.
Well, one of the things I understood Ms. Green to be alleging was that she was required to report findings under DC Code 4-1303.74B.
Oh, yeah, I apologize. You're correct. That is before the court. It's not in the, that's absolutely, that was that's probably the first of them. Yes. My argument there is that it's just not a reasonable interpretation of the law. And interestingly, this new ombudsman law, which of course.
What would be the district's interpretation of that particular provision?
So there's 3 provisions that might allude to findings. There's 3, I think, that she could reasonably rely on. So I want to talk to all 3 of them. The first is the mechanism for receiving and handling complaints. That's at 0.74 sub A. Certainly nothing in that suggests how complaints should be handled. It just says receiving and handling complaints. The second comes under B1, investigate, and this is what the agency's obligations are, to investigate and promptly resolve concerns. Again, resolution does not mean issuing formal findings. And then the third is under B2, and this is about the report, and it requires the agency to report to the council trends and issues that arose and the outcomes of investigations conducted. So
do we need to interpret the statute sort of as a threshold matter before deciding the reasonableness of these issues?
In this case, yes. I could see a case where someone put on other evidence about why it was reasonable to interpret a statute a certain way. My general counsel supervisor told me to interpret it that way. There's other reasons why someone might be reasonable, but in this case, her only argument is that it violated the statute. I will also note, if this court has particular concerns about the findings, that issue came up long before any sort of temporal proximity. So to the extent that, I mean, basically anything that occurred before January of 2017 could also be, first of all, it's not a protected disclosure, but second of all, if the court has concerns about those, there's no indicia of retaliation. And regardless of what the federal government does with its non-frivolous standard, it doesn't have a summary judgment standard. Regardless of what the federal government does, this court has repeatedly held, and recently, that a temporal period of more than 4 months is not reasonable temporal proximity in the absence of other indicia of retaliation. It said that in Johnson, the 2020 decision at note 11, it said that in Tingling-Clemens in note 21, and it said it in Freeman on note 32, all of them quoting the Johnson decision from 2007. So this court's standard is 4 months. So if this court were concerned about the statement that she wanted to issue findings and that she was not being allowed to do so, and thought perhaps that was a protected disclosure, she hasn't shown that that was a basis for retaliation. And especially the same thing goes for her forfeited claim regarding the underreporting of complaints. She made that disclosure 14 months before she was terminated, and the agency's response was, oh, we should really start following the law and do this right. And then they fixed it. So for some of these claims, there's no indicia of retaliation. There's a bunch of different ways to attack this case. You could come at it straight from the angle of why she was terminated. And I don't want to belabor the point, but there's one point in the record that I think is really important. A couple of days after she was terminated, Green wrote to the the court monitor for LaShawn. And she said, the real reason she was terminated is because the agency wanted to strip the job of any ethics and standards. Now, we don't agree with her characterization of that policy dispute, but we do agree that that was why she was terminated. So this court could come at it from that angle. That's the real reason she was terminated. It can read, all it has to do is read the depositions of the 3 supervisors, listen to the March 7th meeting, and read the final decision email on JA 381 to 82 and her response on 377 to 79, and that would be enough to affirm. The court could also go straight to protected disclosures and do what the Superior Court did and say there were no protected disclosures. She hasn't given the basis of any of the things she wanted to set forth in the report. She hasn't given a factual basis for any of it. And so even the stuff that isn't forfeited, she hasn't given a reason why she thought there was a violation, much less a violation beyond what was technical or minimal. She wings only one gross mismanagement argument, and gross mismanagement is still the standard in this court that it has to be not debatable among reasonable people. So I think there's been a conflation of 2 different standards. There's a standard for the disinterested observer. That's just whether the belief was objectively reasonable. That is whether a reasonable person could believe the same thing that the plaintiff believed. But for gross mismanagement or abuse of authority, the conduct has to be serious, which means it needs to be not debatable among reasonable people. And again, this survived the 2010 amendment to the Whistleblower Act. In Holbrook, this court said debatable differences of opinion concerning policy matters are not protected disclosures. That was in 2021. New Quani, it said mere policy disagreements are not enough. And that was in 2020. And I could go on. So I guess what I'm saying is there's a bunch of different ways to attack it. I know my time is up. I want to make sure I'm not missing anything because there's a few things regarding interpretation of the law. So with the court's indulgence, I just want to look through. I'm sure this court wants to talk about perceived as. So if this court doesn't want to reach the question of the operative language of the Whistleblower Act, which does not actually permit a claim arising out of someone who wanted to blow the whistle but didn't. This court doesn't need to reach that question because there's no evidence that the managers thought had any perception that Green was blowing the whistle. Again, Green has sort of changed her argument from her opening brief to her reply brief. In her opening brief, she said the managers perceived her as a whistleblower because they saw her talking to the auditor. Well, they knew she was talking to the auditor because she was talking about a child fatality review committee. It has nothing to do with the disclosures at issue here.
What about her 2017 disclosures? I know I'm jumping around a bit. You said her 2016 disclosures would be precluded under the district's case law about imposing a sort of 4-month rule on proximity, but she made some disclosures in 2017.
I think that anything that came, because all her 2017 disclosures have to do with the annual report. And that was a hot topic all the way up until the month before her termination. So while there are other reasons not to find that that was the basis of her termination, I would not argue there's no temporal proximity there. So that's just a clean cutoff for some of the disclosures before that. But I think this is important that Green's argument now that she was perceived as a whistleblower because she wanted to testify on behalf of the agency at the council hearing is not something she argued in her opening brief. She's changed her argument. In her opening brief, she said she was perceived as a whistleblower because she had some conversations with the court monitor and with the auditor. In her reply brief, she's changing that to testifying before the council. I don't know that this court wants to get into this in this case. The operative language of the Whistleblower Act does not allow for someone to have a civil right of action if they haven't made a protected disclosure. And the federal law is written differently. And so the federal authorities have been able to interpret their law differently. Oh, there was one more thing I wanted to correct from the record. I really appreciate the court's indulgence. I want to talk about the performance evaluation because I think that that's important. And I haven't, because of the way this came up and the arguments came for the first time in the reply brief regarding pretext, I just haven't had a chance to respond in writing. Green argues that she had a positive performance evaluation regarding her writing style. And that's simply not the case. In her reply brief, she cites to her affidavit, and in her affidavit, she says, I got a 3.8 out of 4 in an overall evaluation, but it wasn't out of 4, it was out of 5. And for writing, her evaluation was a 3. So she got a satisfactory evaluation on her writing. And that was before all of the issues with the annual report. I'm giving you a citation. It's JA 199 is where the annual report is itself. And you know it's out of 5 by looking at 6B DCMR 1404.3, which explains the different rankings. If you read her performance evaluation, it corroborates the problems that Chandler was identifying with her performance. So there is no pretext coming out of that. And also, of course, to this court, to the extent that this court is looking at whether there's pretext regarding, not the primary reason for her termination is the insubordination regarding the role of the ombudsman. The unwillingness to hand over data, the unwillingness to work for Chandler, to even meet with Chandler at that point. That's the primary reason. But Chandler did give a couple of other reasons. And those reasons are also all substantiated by the record. So to the extent this court is looking at things like whether her writing was comprehensible, there is a point at which this court can just look at her writing. It's really hard to read. It's hard to understand what she's saying. She's writing something that's supposed to go to the council. When Judge Chandler said this would be a horrible representation of the agency, it would have been. And I think that there's an objective standard there. So I've given this court many different ways to look at this, and I appreciate your indulgence as I went through all my points.
All right. Thank you very much. Appreciate your argument. Mr. Hartnett, excuse me.
That's right, thank you. Picking up where council just left off, the performance appraisal also said that she was able to adjust her communication to the audience and was successful in being able to get her message across. The whole dynamic of, and I don't want to blur the issue again here, but repeatedly council was pointing to claims of insubordination, and the reason that is complicated and definitely needs to go to the jury at least is because what Green was doing, and when she says they want to strip the ethics out of my office, they want to do this or that to my office, and or why she wanted to be able to have different authorities, it was in order to bring the agency in compliance with the FYAA, with the Foster Youth Amendment Act. It created rights and it attempted to create an accountability system. And Ombudsman Green attempted to fulfill that mission.
Can I ask you the same question I asked counsel though? Do we need to definitively interpret the statute before we decide the question?
I don't believe you do. You need to go to reasonable belief is all you need to do. And I believe, I would posit that there's certainly a significant amount of reasonable belief that the Green evidence that the FYI wasn't being complied with. She mentioned that Green was trying to poison the well. She wasn't trying to poison the well. She's trying to be clear with the people who are calling and complaining to her what was going to happen to their complaint. And the agency was representing that they would get confidentiality, they would get a thorough investigation, they would get et cetera, et cetera. And the agency wasn't providing that, or they were interfering with Green's attempt to provide that. I want to commend you actually to read the affidavit that Green wrote in response to the summary judgment motion. Contrary to what counsel just said, it does cite the record. It cites the exhibits in the summary judgment motion where the facts that she's relating turn, and those exhibits are all in the appendix. There are 3 cases that you need to look at, all post the 2010 amendments in the law. So Williams v. Johnson, that's from 2015, 776 F3 865. Coleman v. DC, 794 F3 339 in July of 2015, and Holbrook, which we've discussed before. Those 3 cases will show you how to apply the statute after the amendments. I think it will clarify a lot of the pre-amendment citation that goes on throughout the briefing here for a lot of standards that are no longer applicable under the clear language of the statute.
All right.
Thank you.
Thank you. We'd like to thank all counsel and parties for your briefs and arguments today, and the case is submitted.
All right. This honorable court is now adjourned.
Good job, Reverend Gallo.
Sorry, no. We'll do it next week. I have to do it as well.
I'm on the set.
Oh, okay.